The case, my lord, regularization case was filed in the tribunal. That was dismissed. On dismissal of the case, I am terminated. That is stayed by the tribunal, and thereafter stay has been made absolute. Against the interim order, they have come to this honorable court, where your lordship has granted stay. I have filed vacation of stay. By virtue of this, I am terminated.
That's one appeal bench.
Legal
More
lordship,
than-
pardon me, Lord. Mr. OGLS matter, my Lord, it was remanded back by the Honorable Supreme Court for fresh adjudication. Your lordship also heard the matter at the extent and adjourned the matter to 24th February because the government resolved for production of some record. It has not been listed. Okay.
That's the appeal bench. More than 12 years and
And acquisition compensation matter, sir.
Weekly list item number 1.
Yeah, please. Order dated 25 to 2025. It will be discussed in the maybe committee to committee. Court mark the amount has been sanctioned in favor of the petitioner. We'll discuss in a
It has already been sanctioned. You have
What about the grand total was 31,57,000. Sanction 20,71,000.
That you can challenge.
That
That is
Yes.
different.
Listen, as for the order dated 37/2024, the Land Council for the state has produced the written instruction received from Director RR from Additional Secretary to Government, Department of Water Resources, which indicates about sanction payment of rupees 20,71,379. Towards the decretal used under section 28A of the LAR 1894 in favor of Sudhir Kumar Panda and others. In relation to the judgment dated 26/10/2017 passed by the Senior Civil Judge Nuapada in LAR number 132 of 2010. The latest produced by the Land Council for the state is taken on record. In view of the later, this petition is disposed of. Yes. You have given a copy?
Yes.
Item 2.
I will be allowed to be with Mr. Dhara.
Well, it also looks at the order dated 25/2/2025. That the period of 3 months stipulated in the notice has already been expired when the pertinent question to the client counsel so and so. Any follow-up action as per this? Follow-up action, I have filed the amendment application to incorporate those things now. If you also look at the amendment application,
No, last time the matter was again,
to
time was
bring
taken
your lordship notice about the subsequent development in the meantime.
to file an
Annexure
scheme
9
application
and 10, your lordship looks at. With amendment application. Unless I incorporate that, it cannot be taken into consideration.
What amendment is
That IA number 3591 of 2025.
it? Yes. What have you stated in the amendment?
Amendments, if your lordship looks at annexure 9,
Yeah.
the appeal to regularize the extension, that application is there to the director in charge. Then the subsequent order that has been passed to vacate it within 7 days.
Annexure
Or it
9.
will be taken possession immediately by the authority.
Annexure 9.
Annexure 9 and 10.
Yeah.
10 is the order, which is now the subject matter challenge. I have incorporated in the prayer also.
When did you file the writ application?
The writ application was filed. That's 10/11/2024. These two documents are 19/2/25 is the last document, annexure 10, and 15/11/2020.
No, 15. Sorry, when did you say you filed the writ petition?
10/11.
10/11. Thereafter, you filed the appeal.
Yes, that was filed, and also if your lordship looks at the order that has been passed, is 19/2/2025. That is what your lordship wanted to know.
No. Last occasion that you had filed appeal, that was not brought to a notice. Only
Yes,
because there was
yes.
delay, that is why we questioned.
I'm sorry, my lord, actually. The amendment is also to incorporate those things.
Annexure 10, only 7 days time was given to the petitioner. In the middle, that has expired.
No, 19/2/2025 is not an order passed on that appeal. It is just asking you to.
No, it's an order of.
You made an appeal, right?
This
Yes.
I want to incorporate by way of amendment to the writ petition. This is a clear case of violation of the terms and conditions. They themselves have not complied with the requirement of the terms of the lease, and principle of natural justice has not been followed. That I'll satisfy your lordship.
No, that was beyond. You see the notice dated, notice under annexure 6.
Sir,
It indicates that how you have enforced
sir,
that
I have
additional
disputed
construction has
that.
been made.
Your lordship is absolutely correct. They gave a notice indicating these are the contraventions I have
This
committed.
is the notice as well. Before making that order, they have given you this notice that these are the additional construction.
Exactly.
How can you?
And I have replied it. I have replied saying it has not been done, and there has been no hearing. Your lordship knows that the Sakundala Gauravudu's case, inside section 91(1) of the ODA Act, their lordship said that merely issuing a so-called notice is not sufficient. You must give the personal hearing and make a spot verification after the reply was given to find out whether actually there has been deviation or not, whether it is within the permissible limit or not, and whether there has been any infraction to the law on the subject or not. Here are the terms and conditions of the lease.
Let us see the decision.
Shakuntala Goravadu, my lord.
It's
87,
a
86.
decision in general or confined to the facts of that case?
So 91, they have indicated section 91 also you can see OD Act. OD Act says issue notice. The Honorable Justice R.C. Patnaik said in division.
Let us see the decision, because once a particular land is allotted to you,
Yes, my lord.
and you are supposed to do construction within that
Yes,
particular,
my lord.
and if you deviate it and then you seek for extension and ask to regularize the matter, then
Yes, ma'am.
certainly it is.
So they themselves have floated a scheme saying that anybody who has deviated can file an application for regularization.
Where is that?
Yes, ma'am. If you want to find-
That, if I remember the last of years, but
Whether that is
is,
applicable or
for a
not,
particular
that's the
period,
question.
I think.
No,
For a particular period. It
no,
is-
but that is in general. On that
but if I remember correctly, that day we had examined.
we kindly turn to that document. It's a scheme.
Lecture 4.
Yes,
Something written in the scheme
Lecture
that this
4.
would remain.
sale board at page 38.
Applications not accompanied with the above documents shall not be considered and processed. That is 4.3.
And interestingly, this is within the area. It has not extended beyond it, and much less than the total area that has been given in my favor.
They mentioned about encroachment, so that could not be on that area.
That is dispute. I have not
Disputed, so
disclosed.
how?
And that should be personal hearing. That must be inquiry.
In page number 40, so far as regularization is concerned,
Yes, Maharaj.
it is stated about this area of additional construction.
That I have indicated in the reply.
For additional construction in the leased house, local municipal norms only for areas of construction, but plans so and so may be adopted. No vertical expansion
Yes.
will be permitted in the leased house, and that you have done according to the notice.
So that I want to regularize it because you're within the permissible limit.
Whether it is the scheme permits that.
Yes.
Where is that?
And have a look at the scheme. Page 39 it starts.
Yeah.
The scheme they have indicated in clause 2.
Clause
Then
2
3 fellowship is regularization.
No, regularization, we are on that. See, regulation 3.1.
Area of additional construction.
Yes.
For additional construction in leasehold local municipal norms, so if at plants units may be adopted, vertical expansion will be permitted in leasehold permission.
No vertical expansion will be permitted.
No vertical expansion will be permitted in the leasehold house. Cost of land to use the potato land for construction.
So, no. Other things are there, but so far as this vertical expansion, they have stated in that so far as regularization is also concerned,
Sir,
that will not be permitted. Or if somebody has made the vertical expansion, that would not be regularized. If we have understood it correctly, the other thing can be done, but this is not permissible.
but they have not passed the order to that effect.
No. Then that notice, of course, indicates that vertical expansion has been made somewhere.
Notices at page 44.
40.
44. Annex 6.
Page 44, Annex 6.
You have so and so. You have made additional construction so and so. Published. Where is that vertical one?
4, clause 4.
4. That yes, that if a vertical structure apart from the staircase room of so and so, this square foot or so. This is thing.
They have passed in general order. Actually, I have also indicated the vertical construction that has been made at the LS ballot. I have given a reply to that effect. If you also kindly look at page 45, Annex 7.
Page 45.
Yes, Madam.
Yes.
So I have not crossed the permissible limit of extra construction as alleged, as per information clause 2, Madam. 2. permissible limit of extra construction area as per the information obtained through RTI. I am entitled to construct 60% of the total area, including the existing original structure, which comes to 2,226, which is much more than the RCC area of 1921 square feet. Even taking into account the 230 feet temporary construction is not exceeding the limit. Besides, the temporary construction structures are not to be taken as extra construction as they are temporary in nature. As per information obtained through RTI, RSP authority, I am to entitled to additional construction of 40% of the total area, 3,710 square feet, excluding the existing original structure. Copy address. I am using one room as place of worship in the house, which has compelled me to make a temporary structure over the room where I am worshipping daily. I have not undertaken any RCC construction, but a temporary structure. There is no underground water storage tank, as alleged in the order to meet the emergency, that one missionary tank has been made to store water on the ground. I would further like to submit that the consequence of meetings, so-and-so present DSP, so-and-so, welfare say, besides other matters, it was promised that a scheme will be made to regularize the extra construction undertaken by the leasehold area with the decision of sale board on 314 meeting dated order date 21st and 25th July 2008, which envisaged one regulation of additional construction. They have not passed any order to that effect, right? And the spot
That means, as per your letter, that means scheme was to be floated. So this scheme is not applicable to you.
Scheme is applicable.
Then why have you stated that the scheme was to be floated? In 2024, you've given a reply saying that scheme was to be floated.
The scheme, no, that is actually scheme has to be made applicable. That is on the basis of the scheme I have made an application for regulation.
That
is a one-time settlement. But one cannot repeatedly violate and file application for regulation. It is one time. If I have made an application, it will be considered. Then I can go on repeating, violating, and making construction to make an application.
So which is your application?
So my application is there.
For regularization, which is the application?
Yes.
There's no application.
No.
No, the Annexure 7.
Annexure 7 is the reply to the notice.
No, reply to the notice, Annexure 6.
No, 6 is the notice.
This is the notice.
Oh, sorry.
Sir, Annexure 7, fellowship subject.
Yes.
Request for regularization of additional construction.
There you say, besides other matters, it was promised that a scheme will be made to regularize the extra constructions undertaken.
Yes.
In line with the decision meeting, which
in line with the decision.
One regularization of additional constructions.
Right. There's one time.
That was no one time mean that was notice. These notices keep coming up now and then, valid for a particular period.
So it is.
So there must be a new
there
scheme.
There is no such limitation prescribed in the scheme itself. It is only mentioned is one-time settlement. Annexure 4, if Lordship looks at opening page itself.
This scheme in the page number 39.
Yes, madam.
It is mentioned that the scheme shall come into force with effect from 1st September 2009.
Yes, madam.
And we do not know where is it mentioned that up to which period it will remain in force, and if that period had expired or not. Like you see, Mr. Mishra, ଆମର ଯୋଉ in local ସବୁ ସର୍ବକ୍ଷମା ଆସିଥିଲା. So that was for a particular period. If
that
you now apply under that will not be.
Your Lordship's correct.
Development authority
development authority act.
The development of person development authorities are notified which period they have to apply along with
yes,
that
as per the statute.
Cuttack also same thing happened though.
So modified class.
Here actually those.
Yes, please come to page number 41.
Yes.
Last date of issue of regularization completion certificate 28th February 2009.
Yes.
So the period was there. So
no, issue of regulation completion certificate.
Last date for accepting applications. So 1 month time had been granted for filing applications. So thereafter there must be some new scheme. So this will not be applicable to you.
this scheme अच्छा 2008 रो scheme था मन आसिला कि तादे लिखा है कि এটা applicable হবো
Last
with
date for
effect
accepting
from
applications.
1st September 2009 but how it came 1st September যদি হবো কিন্তু 28 February the last date of regulation of issue of circular so and so last date of making full payment by receipt yeah madam you please see that this scheme the board of directors they took the decision in their meeting which was held on 21st and 25th of July 2008
Yes, sir.
that would be evident from annexure 4
4,
page number 38 right
Yes, sir.
and then the next page says that this scheme shall come into force
And
with
first
effect from September 2009
Yes, sir.
at so and so এই যে জায়গা ওড়াক
Yes, sir.
তারপরে যে পেজটা দিয়েছি you
Yes.
come to page number 41
41.
so if this scheme will come into force from 1st September 2009
Yes, sir.
then how it can be that the last date of issue of regularization or completion certificate would be 28th February 2009 এটা কোন টিকে
Okay. First of all, this
কারণ স্কিম তো আসিলা ଆପଣଙ୍କର ସେପ୍ଟେମ୍ବରରେ ନା
1st September
ହଁ
the
এটা ତା
last date of
ପୂର୍ବରୁ ହେଇଯାଉଛି ତାର 7 ମାସ ପୂର୍ବରୁ ସରି ଯାଉଛି ନା ଏଟା କଣ ଅଲଗା ଜିନିଷ
So it is possible they may have given schemes every year and they have annexed a scheme
maybe
next year.
this land belongs to SAIL, Steel Authority of India. The land belongs to Steel Authority of India. RSP is the competent authority. So RSP or SAIL would be the right person.
Yeah,
to
no,
ask.
we are just asking you for your assistance.
Yes, sir. Page 41 makes a clear picture also. The last date of accepting application is 30th September 2008, Your Lordship.
So it seems as if every year, every 2-3 years, they must be doing that, though we can't be sure. This is the next year.
Can I just
you have received the copy of the Indian notification
Yes, sir.
IN number 3591 of 2025 is an application for amendment of the writ petition. The
May I, Your Lordship? So kindly see page 39 for a minute.
39.
Huh.
Yes.
39, first paragraph. Your Lordship. Second line, this is one-time effort to regularize unauthorized construction in the houses leased under sale scheme for leasing of houses to employees implemented during 2001 to 2003.
Yes.
This scheme may not be applicable to the petitioner.
No, that is one thing. Let them amend it. We will consider it on the next date. Could be possible every 3-4 years they may be giving.
There may be
They used to float such type of scheme.
maybe.
Once in a while.
এই মଝିରେ ମଝିରେ ଏମିତି ଆଜି ସର୍ବକ୍ଷମ ଯୋଜନା ମଧ୍ୟ ମଝିରେ ମଝିରେ ଆସେ ସେ ନହେଲେ ଥରେ ହେଇଗଲା ମାନେ ପୁରା ହେଇଗଲା ପୁଣି କେତେବେଳେ ଡିସିସନ ନିଆଯିବ ଆଉ କିଛି ଗୋଟେ ରହିଯାଇଛି ଆଉ ପୁଣି ଗୋଟେ ଫ୍ଲୋଟ କରିଦିଅ ତ ଏଇ ଟାଇପ
Because in the rejection order they are not referring to any scheme also.
They're not they're not applied. In fact, that is a reply to the notice, it seems.
and by the way ଏଇ ଯୋଉ ଆପଣଙ୍କର notice ଟା ଯୋଉ issue କରିଥିଲେ
Annexure 6.
ନାଇଁ first notice ଟା annexure 6 ହଁ ଏଇ ଯୋଉ ଆପଣ ଲେଖିଲେ ଯେ ଏଇ additional construction ହେଇଛି ଆମକୁ ଏଇ ସବୁ ଜିନିଷ ଗୁଡାକ how on what basis you came to there must be some kind of measurement and that measurement should be
There must be some measurement
in presence of the party also ଆପଣ ଯଦି ପକ୍ଷର ଉପସ୍ଥିତିରେ ନ ନେଇକିନି ଅଫିସରେ ବସିକିନି ଗୁଡା କଣ ଲେଖିଦେଇ ପାରିବେ କି
there must be some field verification and thereafter this
ଆପଣ ପ୍ରଥମେ ଆଗେ ନୋଟିସ ଦେବା କଥା ଯେ ଆମେ ଏଇ ମେଜରମେଣ୍ଟ କରିବୁ ଆପଣ ଉପସ୍ଥିତ ରୁହନ୍ତୁ ତାପରେ ଇନ ପ୍ରେଜେନ୍ସ ଅଫ ପକ୍ଷ ଆପଣ ମେଜରମେଣ୍ଟ କଲେ ଦେଖିଲେ ଏଇ ସବୁ ଡେଭିଏସନ ଅଛି then you can issue notice of irregularities in that sub-lease premises. ଏଥିରୁ କିଛି ଜଣା ପଡୁନି ଏଇ ଯୋଉ notice under annexure 6 ରୁ
Yes.
ଯେ ସେଇ type ର କିଛି procedure prior to the issuance of notice has been followed.
In course of the day, I'll file one. Sir, But in this case, 93, from 93, he is in occupation of that quarter which has been allotted in his favor. No, the only thing is that now they have given 7 days to break it. Day after. Sir, day after tomorrow. Great.
Item 3.
Sir, the lighter side of it, if you are and the lighter side of it, can I just congratulate you, Lordship? So yesterday's victory. You all have seen
Item 3.
My lord, the petition of house and land already taken over by the LA collector, my lord. The order is not complied with page 11, order person.
Which portion, which part of the order has not been complied?
My lord, paragraph 4, my lord. Considering the contentions raised by counsel for the parties and after going through the records, court disposes repeats on directing OP number 5 to consider the recommendation made by the OP number 2, next 2.
So that was to be considered from the date of production of the certified copy.
My lord.
So when you produce the certified copy, what is the averment to that effect?
31st August 2023.
Please show the averment in your contempt petition.
Receipt is also there.
Okay, 31st August 2020.
Receipt is.
Quick instruction. This
4
contempt
weeks
petition
time.
has been filed for non-compliance of the order dated 9/8/2023. Passed in WPC numbers 1. So, in the operating portion of the order, it is as follows for the paragraph number 4. The land counsel for the petitioner submits that the order was communicated to the contender on 31/8/2023 to speed post, and the receipt of acknowledgement. You have filed that receipt of acknowledgement?
Page 11.
Page 11.
Receipt.
अच्छा ये बड़ा दूसरा नहीं था अच्छा. Filed. Land counsel for the state took some time to obtain instruction. In the matter, out of this matter.
4 weeks time.
When did you communicate the order?
But
communicate order.
31st August 23
Paragraph
31
एकतीस आठ
paragraph
आगे।
number 2 ରେ ଲେଖା ହେଇଛି।
फाइल केबे गले कंटेम्प्ट
କଣ୍ଟେମ୍ପ କଲୁ 21/5 ରେ 24 ରେ
3624.
ओ कम्युनिकेटेड ऑन 31/8/2023
ତାର 3 ମାସ ଭିତରେ କରିବା।
then filed on 21
21/5/2024
all right ठीक ଅଛି
तो କେତେ ରହୁଛି? ତ ସେ କହୁଛନ୍ତି 4 week।
ସେ କଣ
15
ହଁ
15 April 2025 yes
Item 4.
4 to 12. Yeah, estimated over from the new LAO special LA joined 2 days back. Suffer 1 week time to provide the instruction about the compliance of the order. Or 28 application was provided.
1 week time
1 week time.
all right
फ्रेश कॉस्ट टाइटल फाइल करनाହାନ୍ତି इंस्ट्रक्शन तो रखते हैं 2 weeks
it seems that as per the order dated 6/2/2025 fresh cost title has not yet been filed. The land council for the state seeks some further time to obtain the status of representation filed by the petitioner. From opposite party number 3. Opposite
She was
party.
direction was the special
Alright.
to comply. Other two have deleted by a
So ଗୋଟେ ସପ୍ତାହ में ଛାड़ ଦଉଛୁ
ଆଜ୍ଞା
let it come on 24th
of next month.
सेम ऑर्डर
24
4 to 2 bar.
non ଆସିଲେ କିଛି ଲେଖିବେନି 1000
हाँ जो ऊपर काउंसिलर ना लिखे नथिबे ना पे लिखिया दरकार काउंसिलर ना
तो ये जो 4 5 6 7 एटा सब तो
12 दिन
खाली 12 रे रहिबनी जे से जो ये नॉट फाइल्ड बोली अदर नोटिंग कहीं नहीं भूले छाड़ी गला ना कौन
12 नंबर का दे देखिए नहीं सी टाइप रो ऑर्डर
same order.
नहीं तार से लिखिया पे
okay.
किछ नथिबे
नहीं fresh cost title भी फाइल लिखा है
अच्छी
ये जो next page number 2 रे third sub paragraph permission is granted ଗୋଟେ line जोटा ता पूर्व page टा out of
ओहो करे
ଗୋଟେ line
अच्छा अच्छा
same order for
नोटिंग का देन के
Noting
रीडिंग
का-
असिस्टेंट आ गोटे रीडिंग असिस्टेंट को से लिखना
हाँ तो 24 24 2025 yes
Item 13.
Limited prayer to annexure 3 to dispose of sent for 64 but এটা collector through রে মন্ডল অধিকারী
when we made a specific query to the land and council for the petitioner as to whether in terms of section 64 so and so any written application has been made to the opposite party number 3 the collector Margunj for referring the case of the petitioner to the authority or not and council seeks some time to obtain instruction in the matter
In the main of the last occasion, your lordships had this matter. That matter, instead of collector, the representation to refer the matter to the competent authority was addressed to the land acquisition officer. So in the meantime, she has already approached the collector.
तो यही तो किसी हबनी आदरे ଆପଣ ଯଦି ଏବେ ଫାଇଲ କଲେ then
परसू करे
you pursue କରନ୍ତୁ ଆପଣ ଏଇଟାକୁ withdraw କରିନିଅନ୍ତୁ we will dispose of that the next heard Mr. Niranjan Lanka and counsel for the petitioner land counsel for the petitioner as for the order dated 19 to 2025 has taken instruction that no written application had earlier been filed before the opposite party number 3, the collector Mohammed, for referring the case of the petitioner to the authority. However, in the meantime, Quebec Vocale,
On the 1st of March 2025, this is the
1st of March 2025, he has filed, the petitioner has filed such application before the opposite party number 3.
with no 2 months. 3.
Three collector.
This is fine. This
But on 3 collector months.
petitioner now to pursue the such application before the opposite party number 3. Accordingly, the writ petition is disposed of. Yes.
Item 14.
The petitioner was the recorded owner of the land 58 decimal slot number 1440 khata number 51 Mauja Dharmagad district of Kolam.
What is this word access the compensation in the prayer portion?
That notice
No. What is the meaning of this word access the compensation in respect of conflict?
Access I have said.
Page 9%. Whether that word is correct or not?
access grant
Hmm?
grant
What happened?
Grant nahi. Copy paste मार दो जिन्होंने तो बुझुनांती हो.
Access or not access. Yes. So your land has been acquired in this area, so on so as you
Right.
stated. And where is the documentary proof that your land has been acquired? Or
Sir, an inquiry report of
where is that?
sir, inquiry report 9 is in page 16.
Page 16.
Joint field visit by
Please read it out. Please read it.
Sarpanch.
Sub-Regional Magistrate Dharamgarh, it has passed the order. Reduce the joint sworn so by. Please read it out.
Huh?
अरे पढ़ो तू.
pursued the joint field visit memorandum submitted by Revenue Inspector Haipada, Revenue Inspector Rural, Revenue Inspector Parla, Port Omin, Dharmagad, Revenue Supervisor Dharmagad, Tahsildar Dharmagad, JRD Dharmagad, filed memo number 2953 grievance dated 5/7/2024, where it is stated that the construction work of road from Gambhariguda, Haripada is obstructed by one Sri Krishna Saraf. Krishna Saraf is already dead. Petitioner is the son. Sir Krishna Saraf, son of Amasaraf of village Melgora, is Thermo district Kolandi, for the land secured, of which is even below under the local limit of this code. Further, it is reported that the below mentioned land has been used as a road by the local public since 30 years, as stated by Sarpanch. India and Nergara villages.
Annexure 4 is copy of inquiry report. Annexure 4 is the application. Index answer बोलो.
Annexure page 16 जो order है on the basis of inquiry under annexure 4.
Annexure 5
खाली ଗୋଟେ inquiry genealogy inquiry ଆଉ କିଛି ନାହିଁ.
5 ହେଲା.
ସେଟା 166 BNSS ରେ ସେଟା order ହେଇଛି. but the acquisition document ଟା যেଟା ଦେଇନାହାନ୍ତି ସେଟା ଦେଲେ ଜଣା ପଡିବ ଯେ whether
ମାନେ ଆକ୍ୟୁଜେସନ ନ କରିକି ରାସ୍ତା କରିଦେଇଥିବେ ବଟ୍ ଇଏ ତ କହୁଛନ୍ତି 30 ବର୍ଷ ହେଲା ଲୋକ କଣ କରୁଛନ୍ତି ଇଏ କଣ ଗୋଟେ ଦେଇଛନ୍ତି ଟ୍ୟାକ୍ସ ଟା ଗୋଟେ ଏବେ କଣ
ହଁ ସାର୍
ଏବେ ସାଙ୍ଗେ ସାଙ୍ଗେ ଗୋଟେ କଣ ଟ୍ୟାକ୍ସ ଦେଇ ଦେଇଛନ୍ତି that must be without prejudice ସେ ମନ ଇଚ୍ଛା ଲୋକ ଦିଅନ୍ତି ବୋଲି ଏଟା without prejudice ଲେଖା ହୁଏ ଏଟା ତ ଏବେ ରିସେଣ୍ଟଲି ଦେଲେ ଆଗରୁ ଦେଇଛନ୍ତି ନା ନାଇଁ ଏରିୟର ପରା 00 କରେଣ୍ଟ ଏତିକି ତା ପୂର୍ବ ରିସିପ୍ଟ କାଇଁ
ସର୍ବମୋଟ ଦାଖଲ ଟଙ୍କା 2707
ସର୍ବମୋଟ ମାନେ ଟୋଟାଲ ଏତିକି ପଇସା ଦେଲେ
ଏଇ particular ଯୋଉ land ଟା ଉପରେ road ପଡିଛି public use କରୁଛନ୍ତି 30 ବର୍ଷ ହେଲାଣି ଖାତା ନମ୍ବର 51 plot number 1440 ଆଉ ତାର ଏରିଆ ହଉଛି ଏତିକି ଏଇଟା ଆପଣଙ୍କର ବୋଲି କୋଉଠି ଡକୁମେଣ୍ଟରେ ଦେଇଦେବେ କୋଉ ଜାଗାଟା କହିଲେ ଆପଣଙ୍କର ଏଇଟା 1440 କାଇଁ
1440 ପତିତ
ଗ୍ରାମ୍ୟ ରାସ୍ତା ଗ୍ରାମ୍ୟ ରାସ୍ତା ହିସାବରେ ଲେଖା ହେଇଯାଇଛି
ଏଇଟା କେବେକାର ଆରଆର 2014 ନା ଏଇଟା
ଅନ୍ତିମ ପ୍ରକାଶନ ହଉଛି
13 ସେପ୍ଟେମ୍ବର
ଖଞ୍ଜଣା ଧାର୍ଯ୍ୟ କରିଦେଇଛନ୍ତି 2014
ସେତେବେଳେ ଥିଲା ଆପଣଙ୍କର ତାପରେ ଗୋଟେ କଣ ଅସୁବିଧା 13/2019 ର ପୁରା କେସ୍ ଗୁଡା ରେଫର ହେଇଛି ତା ଉପରେ ତ ଆର ଇସ୍ୟୁ ଡେଟ୍ ଟା ଏବେ କେବେ ଦାଖଲ ଖାରଜ କେସ୍ ଏତିକିରେ ହୁକୁମ ମୁତାବିକ ପ୍ଲଟ ନମ୍ବର ଏତିକି ଖାରଜ ହୋଇ ନୂତନ ଖାତା ଦାଖଲ ଖାରଜ କେସ୍ ଚାରି 11/2023 ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇ ଆସନ୍ତି ଲୋକଟାର ଜାଗା ନେଇଥିଲେ କୋଉଠି ଲେଖିଛନ୍ତି ଆପଣ ତାକୁ ଆଚ୍ଛା ଦେଇଛନ୍ତି ନାଇଁ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଲେ ହବନି ମ କୋଉଠି ଆପଣଙ୍କର ପେଟିସନ ରେ ଲେଖିଲେ ହାଉ ୟୁ ଆର୍ ରିଲେଟେଡ୍ ଟୁ ଦ୍ୟାଟ୍ ପ୍ରଶ୍ନ ଆଉ ଆନେକ୍ସର କୁ ପଏଣ୍ଟ କରିବେନି ଏଠି ଗଭର୍ନମେଣ୍ଟ ହ୍ୟାଜ ଟୁ ବି देयर ଅନ୍ ଆଫିଡେଭିଟ୍ petitioner is the recorded owner ସରିଗଲା ଆଉ you are the recorded owner first line of the writ petition ସରିଗଲା ସେଠି
ଆଚ୍ଛା ଏଠି ଅବଶ୍ୟ ଲେଖିଛନ୍ତି paragraph 4 ରେ that it is pertinent to mention here that this so it was recorded in the name of the father of the petitioner while issuing so
ଦିଟା ଜିନିଷ ଖାଲି ଦରକାର ଯେ you are the sole legal heir ନା ଏଇଠି 4 ଯୋଉ ଠିକ ଅଛି ସେଠି ଲେଖିଲେ ଯେ father of the petitioner anyway the instruction ଆଣନ୍ତୁ then thereafter we can discuss
this petition has been filed by the petitioner Ketu Saraf the direction of to the opposite parties more particularly to the opposite party number 3 collected from district magistrate Kalahandi to assess the compensation in respect of area Ecosum 5 decimal of land pertaining to plot number 1440 under Khata number 51 of Mauja, Meragara, and to disburse the same in favor of the petitioner within stipulated period. The Land Council for the petitioner has referred to the ROR under Annexure 2 to show that the land in question has been recorded in the name of the father of the petitioner. Land Council for the petitioner further to the attention of this court Annexure 3, which is the order passed by the Sub-Regional Magistrate Dharamgarh in CMC number 65 of 2024, which would show that the land in question has been used for public road since last 30 years. Then counsel for the state seeks some time to obtain instruction in the matter.
क्या रेफर कर दूं?
The then counsel for the petitioner further to the attention of the court to annexure 4 to show that
Krishna Chandra Saraf has died on
that Krishna Chandra Saraf, the father of the petitioner, has died. And
on 5/9/2005. अच्छी good death certificate ता पछरे अछि.
5/9/2005, and the genealogy has been mentioned in the annexure 4. ତାପରେ ତା instruction ନେବେ କେବେ ରଖିବା ଫୋନ
2 weeks after.
weeks ମାନେ କେବେ ରଖିବା
नहीं सब सकते.
7th. All right.
I man.
IE କଣ ହବ? What IE you want?
ରାସ୍ତା ତ ହେଇଯାଇଛି ନା।
ରାସ୍ତା ତ ହେଇଯାଇଛି, ସେ ଲୋକ ପବ୍ଲିକ ୟୁଜ କରୁଛନ୍ତି, ଜମିଟା ତ
आईटा कौन आई?
ଯଦି ଆରଡି ରୋଡ ହେଲେ ବି ଗଭର୍ଣ୍ଣମେଣ୍ଟର ପ୍ରୋଭିଜନ ନାହିଁ।
अच्छा ये ଯାହାହେଲେ ତ ଆପଣଙ୍କୁ ପଇସା ମିଳିବ ଆଉ।
7/4/2025. Yes.
Item 15.
Last occasion, Lordship directed to produce the order sheet of the land acquisition officer manual. I have received it today, my lord, and you want time to file.
The learning counsel for the petitioner submits that he has received the order sheet in case number 20 of
details देखना ना डालें ऐसा काउंसिल करो
and you will file the same during course of this week.
My lord, by 14 days.
During course of this week, and you want it to be listed next week. The matter may be taken up next week.
अपन ना डाल
Give your name.
Our अच्छी होती है.
ने पावर अच्छी बात है जे नाटा कौन कोन तू कहना मिस्टर एसके द्विवेदी का नाटा अच्छी और नॉट मिस्टर एसके द्विवेदी
नहीं आइटम
आइटम
14 शिवशंकर सामंतरा আছে आइटम 14
नहीं सेटा सरीला सेटा तो हेटी काउंसिल करले
We are in
अपन
item
नाट कोन
शिवशंकर सामंतरा.
हां सेटा लिखि दे 14 रे 15 रे कोन अपन ना
सत्य शिवदास
तो नाटा कोठी अछि
It will come next week, 17/3/2025. Okay.
on behalf of it
On behalf of Mr. Surya Kanti.
Item 16.
16, my lord, on behalf of Ms. Mahapatra.
ଆପଣଙ୍କର ପାୱାର ଅଛି ନା ସି
My lord.
କରିବେ
My lord. ସେ କରିବେ ଯେ instruction was to call for regarding status of KLC number 109 of 16, my lord.
Yes, my lord. I press on next week. We are not taking the instruction, my lord. They send the letter, but instruction not been received.
All right, then counsel for the state seeks some more time to obtain instruction in terms of the order dated 19/2/2025. Put of this matter will be continuing from 24th March 2025.
डेटा पुଣି ଆସିବ
24
हां 24
सर please commencing नॉलेज पूरा 24 लोग 24 मार्च 2025.
जे पंडा लिखिदेबे
हाँ, Mr. J. Pandal appears to be virtual mode for them.
Item 17.
Nothing, your lordship. Lordships, on the last occasion, your lordships have asked a pertinent question that on the instance of petitioner number 1, which is an unregistered organization, association, whether the petition is maintainable. I prepared a written note of submission with some judgment.
So normally it should not be permitted, but in exceptional cases you can be.
Yes.
That is what.
Give those citations to the state council. Let him go through it and we'll take up this matter.
State council.
ଖାଲି ପହରଦିନ
ସିଏ ହେଲେ ଷ୍ଟେଟ୍ କାଉନସିଲ କୋର୍ଟର ଦେଲେ ପହରଦିନ
we'll take up their day after tomorrow. The land council for the petitioners has filed some citations. ଆଉ କଣ ଦେଇଛନ୍ତି citation ସାଙ୍ଗରେ? ଖାଲି ତ
Decision ଗୁଡା
not the-
citation decision ଗୁଡା
citations just taken on record.
Your Mr. Behura or
With the written note of submission. Written note of submission regarding maintainability along with some citations which are taken on record. Copy of the same has also been furnished to the land council for the state to seek some time to go through this and put up this matter on 12th of Chita, 12th of March 2020.
Actually, 20 is identical. Same.
Acha, list this matter along with
20, but there was no order there.
No, it is registered for the
खाली last two for
listed for
this matter along with one. Acha, each 17
ସେଇଟାରେ
number.
କରିବନି ଏଇଟାରେ କରିଦବା ଏଇଟାର ଲିଷ୍ଟ ହେଲା ଏଇଟାରେ କରିଦବା
This matter along with item number 20.
ସେଇଟାରେ କରିବନି ଏଇଟାରେ କରିବ ତା ଦେହରେ ତ କିଛି ନୂଆଟା ହେଲା ଏଇଟା
ଏଇଟାର ଅର୍ଡର ହେଇଥିଲା ସେ କରିବା ପାଇଁ ସେଟାର କିଛି ଅର୍ଡର ବୋଧେ ହେଇନଥିଲା
ହେଇନି ବଟ୍ ସେଇଟା ମେଣ୍ଟେନ୍ କରିଦେଲେ ଏଇଟା ବି ହବ ସେ ଯେ ଏଇଟାରେ ସବୁ ସିମିଲାର କ୍ୱେଶ୍ଚନ୍ ଇଜ ଇନଭଲ୍ଭ ସୋ ମେ ବି ଲିଷ୍ଟ
ସେ ଅର୍ଡର ହିଁ କୋଡିଏରେ ଅର୍ଡର କିଛି ପାଇছে
ନାଇଁ ମୁଁ ଜାଣିଛି ଆଜି ଅର୍ଡର କରିଦବା କରିବା
ହଁ the land for the କୋଡିଏରେ ଲେଖି ଦିଅନ୍ତୁ the land council for the petitioners submits that this matter is similar to item number WPC number 5267 of 2025. And the matter will be listed along with such a petition. This matter along with WPC number so and so on 12th of March 2025. Dr. BSU, March 2025 with item number 20.
Item 18.
Mr. Devra, Samarendra Devra.
May I please your lordship? I'm on virtual mode. A lease of a government land was granted by the municipality in favor of one Nomani in 1960. Thereafter, it was page 23 of the brief. Page 23, it was last renewed in favor of the successor of the initial lessee in favor of Niyati Chakravarti with effect from 10/1/1980. Now, on expiry of the lease, they exercise the option for renewal. That's at page 29. While the application for renewal was pending, there was a change in the law which provided for, and there was a litigation between the municipality and the state of Orissa as to who is the owner of the land. It was decided in that litigation that the state will be the owner of the land. And as per the provisions of the OGLS Act, an application was made under Annexure 5 at page 33 for settlement of the land in favor of the petitioners under the provisions of the OGLS Act. Now that application has remained pending. The latest record of rights are at page 41. Where the khata has been recorded in favor of Sarkari, in favor of the government. But if your lordship takes page 50, 50,
Yes.
page 50, Plot number 608, Potasutre Dokhal Gunamani Banerjee, Swami Amuko, Rajendra Kumar Amuko, etc. So Potasutre Dokhalkar, my predecessor in interest. Thereafter, in 1980, they have renewed the lease in favor of Niyati Chakravarti. But anyway, that being the position, suddenly, under Annexure 8, they said that issued a notice, the Tehsil issued a notice that ଏକ ସରକାରୀ କୋଠା ବିପଦ ସଂକୁଳ ଅବସ୍ଥାରେ ରହିଛି ଯାହା ପୂର୍ବ ବିଭାଗ ଦ୍ୱାରା ଅସୁରକ୍ଷିତ ଘୋଷଣା କରାଯାଇଛି ଏହା ଦ୍ୱାରା ଜନଜୀବନ ପ୍ରତି ଆଶଙ୍କା ରହିଛି ମାନେ ସରକାରୀ କହିକିରି ତାକୁ ଡେମୋଲିଶ କଲେ. So I made a representation under Annexure 9 that be that as it may, you kindly settle the land if you thought that it was unsafe, you have demolished it, but kindly settle the land in my favor. Annexure 9, I made that application. Now, in the meantime, the government has also come out with a notification. Annexure 10 at page 54. This is at the draft stage. The following draft of certain rules further to amend Odisha Government Land Settlement Rules 19 so and the state government proposes to make exercise of powers conferred under so and so is hereby published as required under subsection 1 as the said section for information of all persons likely to be affected, etc., etc. Thereafter, your lordship sees section 3 of therein.
So this is the objection and suggestion was
Invited. It, to my knowledge, in the public domain, what has happened thereafter is not available. The state would be in a position to tell us. Now, at page 55, your lordship sees 5AB. Notwithstanding anything contained in Rule 3, 5, 5C, 8, so and so of the government land leased out by Puri municipality under the Odisha Municipal Act or under any other law which was in force at the time of granting of such lease, whether renewed or expired, shall be settled on lease basis with the person in occupation of such land. So the law provides that it has to be settled in my favor. But this is at a draft stage. But be that as it may, even under section 3, subsection 4A of the OGLS Act, somebody who has been in possession of the land for 3 years, the land is liable to be settled in his favor, in his or her favor.
So what is the status, Mr. Mukherjee? What is the status of this notification thereafter? Because
in public domain, nothing more is available. After this draft stage, I think the State Council can take instructions as to what is the present status of this notification. In the public domain, nothing else is available.
Mr. Naik.
Here in this case, my lord, initially lease was granted one to Unnamai Banerjee. And after his death, his husband Rajendra Banerjee, that as a successor, the lease has come. Thereafter, Rajendra Banerjee gifted the present Nitya Chakravarti.
Niyati.
Yes, so that has been leased out to her on basis of the transfer.
These are
the legal heirs of Niyati.
And here in the municipality, executive municipality is the party in this case, my lord, and here is the that here in this case, municipality also made as in this party, opposite party, because their municipality is not in made as a party.
No, this land was leased by Puri municipality. Mr. Mukherjee?
It was initially leased by the municipality.
Yes.
But in a litigation between the municipality and the state government,
yes,
all these lands are vested in the state. And that is the notification which I showed to your lordship. The gazette notification that whether it is leased out by the municipality, the government, it will be leased out settled by the government.
No, but about the authenticity of this document which you have filed, Annexure 2, for ascertaining that what he says that the municipality should have been made as a party to this writ petition. Annexure 2 is the document which was
Municipality has
executed by the Puri municipality executive officer with one of the persons from whom you are telling that you have got the same.
Your Lordship may permit me to include the municipality. That's not difficult. I will include the municipality as a party.
All right, you make necessary amendment, and in the meantime, let him obtain instruction about the status of, because this 6th December 2023 Gazette notification indicates that objection were invited from public, and that was for a period of 1 month. And in that amendment, if it is carried out, then it says that if it is Puri municipality has leased out the land, it will be settled, plain and simple thing. So it appears that so whether this all these things have been incorporated or inserted or not, that you can take instruction in this matter. This hard amendment rules, the draft he has given.
Mr. Mukherjee,
Yes.
even without this amendment, under Rule 5B of the OGLS rules, under which that Schedule 5 has been published, won't you be eligible?
I will be eligible. I will be directly eligible under Section 3, subsection 4 of the OGLS Act.
Specific
Now they have specifically provided for
Yes.
lands which have been leased out by the municipality.
Hard Mr. Kosam Mukherjee and senior advocate. The petitioners, so and so, have filed this petition. With a prayer for settlement of the land. Where is the schedule of land where you have mentioned that?
The schedule of land is mentioned in para 3. Para 3.
Para?
3. Page 4 of the writ petition.
Land as mentioned in paragraph 3 of the writ petitions. To be settled in favor of the petitioner as per the provisions of Odisha Government Land Settlement Act and rules. The Land Council for the state submitted that the lease deed was executed by the executive officer, Puri municipality, in favor of
in the predecessor of interest of the petitioners, present petitioners.
Number of petitioners, not only one.
Niyati Chakravarti. However, the Puri municipality has not been arrayed as a party in the writ petition. Mr. Mukherjee and senior advocate submits that will make necessary amendment in the writ petition for addition of so and so as one of the opposite parties. During course of argument, he has drawn the attention of this court to the Gazette notification dated 6th December 2023 of Revenue and Disaster Management, which shows that a draft of Odisha Government Land Settlement Hard Amendment Rules 2023 was prepared, and the objection and suggestion was invited from the public, and it was stated that draft will be taken into consideration on or after expiry of a period of 30 days from the date of publication of the notification in the Odisha Gazette. Mr. Mukherjee Land Council submits that he is not aware whether about the present status of the draft notification. Stop. Let the Land Council for the state of the instruction in that respect put up this matter. We'll take up this matter on 24th. This matter on 24th of March 2025. Yes.
I've made an interim application that no third party interest be created in respect to the land in the meantime.
ସେଠି କିଏ ରହିବ ସେଇ ଗୋଟା ଘରଟା କଣ ଭାଙ୍ଗିବାକୁ ଆସିଲାଣି ତ
ଭାଙ୍ଗିଦେଲେ ନାହିଁ, ସେମାନେ
ତିଆରି
କହୁଛନ୍ତି ଆର୍ଆଇ ଅଫିସ କରିବେ, ସେମାନେ ଆର୍ଆଇ ଅଫିସ କରିବେ ସେଠି, ସେଇପାଇଁ that is my
IN number 1517 of 2025. Status quo as on date in respect of the land mentioned in paragraph number 3 the likhi debe pura swan so shall be maintained in the next day. Yes.
oblige.
Item 19.
Yes, regarding settlement of the land or the mutation proceeding, it lordship has passed a similar order. Tinta file hitla. It is the second one. I would test.
No pass similar order. Okay. Mutation notice ଟା ଚାଲୁ କଲେ ଆମେ ଠିକ ଅଛି ଆଉ ଗୋଟେ ଦଉଛନ୍ତି ଦିଅନ୍ତୁ ଦିଅନ୍ତୁ ସେମିତି ଦିଅନ୍ତୁ ସେ ଟାଇମ କଲା ବେଳେ 10 ମିନିଟ ଲାଗୁଛି ସେଟା ଦେଲା ବେଳେ ବି ଆପଣ କରିପାରିବେ
Same, party is same. We approach the mutating authority.
To withdraw one.
ସେ ଭାବିଲେ କଣ ଅର୍ଡର ପାସ୍ ହେଇଛି
We thought some order has been passed.
what order we could have passed when you are challenging mutation notice.
All right, next.
Madam, may I pray? I would tell you.
अरे मेमो देला
You
आସୁନି
give
कि
the memo. How is the Ashti there? File the memo, yes.
Item 21.
Order has been complied. Yes. Comply ହେଲାଣି? This contempt petition has been filed.
Another date may be fixed by the reading this.
On another day.
Lordship, any order had not, any letter had not been passed by this authority to the petitioner.
Has already been
I
filed.
have no knowledge regarding this
No,
letter.
ଆପଣ
लिखित
ବର୍ତ୍ତମାନ
ଅଛି।
knowledge. Want to file for this purpose. The Land Council for the state has obtained instruction from the select. এটা কাহার instruction নেই district magistrate and so on. According the later dated so on, which indicates that the order has already been complied with, and the representation filed by the petitioner claiming for payment of compensation in respect of the land has been rejected. The document has been taken on record. Contempt petition is disposed of.
And liberty may be granted to
Liberty is
challenge.
granted to this one so to challenge this order in the court appropriate. Yes.
Item 22. Your Lordship, I'm alleging the deliberate non-compliance of the order dated 24/9/2022 passed by this honorable court, wherein a direction was given to pay compensation to the petitioners, Your Lordship. Your Lordship, the order was communicated on 3/10/2024 and a
Wait,
specific.
just a minute. Review the letter of the collector for government letter fee and valuation report furnished by the executive engineer. R&D for the opposite party number 5 under annexure 4 and after hearing this one. That is already determined here. If assess is not 4,98,000 so on so. Then in spite of so on so valuation you have not will also communicate the order.
Yes, Your Lordship. On
They will produce date of
3/10/2024, Your Lordship.
publication
It's annexed in page 15, Your Lordship.
3/10/24. Here are the documents.
1 month, we had given 1 month.
The election was to comply within 1 month, Your Lordship.
I think similar matter was listed
Yes, Your Lordship. Few weeks back.
few weeks back.
So who is
You
to
get instruction or
the human national highway authority?
Acha,
So
notice jo.
This contempt petition has been filed for non-compliance of the order dated 24/9/2022, passed in WPC number 23390 of 2024. In the operating part of the order, it is observed as follows. In view of the letter rule, paragraph page number 3 rule, page number 4 रे जो भी authority compliance represent the land council for the petitioner submits that the petitioner produce the certified copy of the order. Send the certified copy of the order by post to the opposite party on 3/10/2023, and in spite of that, the order has not been complied with. Issue notice to the opposite party contempt requisites for issuance of notice required. Will be filed
Within 3 days, Your Lordship.
within 3 days. Matter will be issued 8 days.
Telephone सप्ताह पर 5,000 नहीं returnable within 4 weeks. 6 weeks था 10 21
21st April 2020. Yes.
Next, Your Lordship.
Next time.
Same, Your Lordship.
Next time actually.
Item 24.
With pattern, my lordship. Item number 21, my lordship. Kindly may allow my lordship.
Mr. You are Mr. Behra.
My lordship.
Your representation has been rejected.
My lordship on this my lordship ସେଇଥିପାଇଁ ମୁଁ ଆଜ୍ଞା ଫାଇଲ କରିଥିଲି ଯୋଉ ଜିନିଷଟା my lordship ସେ ମେନସନ କରିଛନ୍ତି ସେଥିରେ କୌଣସି ଡକ୍ୟୁମେଣ୍ଟ ଦେଇନାହାନ୍ତି କୌଣସି ସ୍ପେସିଫିକ ମେନସନ କରିନାହାନ୍ତି my lordship.
ଆପଣଙ୍କୁ କୁହାହେଇଛି you can challenge that order.
Challenge that.
We have granted you that liberty.
Content petition no scope is limited. आपण करथिले मो रिप्रेजेंटेशन ता डिस्पोज ऑफ है
My lordship.
रिप्रेजेंटेशन डिस्पोज ऑफ है आपनकर क्लेम ता रिजेक्ट कर दिजन मु सेटा को चैलेंज करिबे और
Please, Your Lordship. Here, my lord, I have filed a IA that is 3303 of 25. I have already served the copy upon the running council of advocate and as well as also the private counsel.
So any objection? What is the amendment?
My lord, now I want to annex the document regarding the order passed in WPC number 5772 of 2004. Though I have taken such writ application in this writ application.
You have taken such averment.
Sorry, I have already taken such averment in this writ application.
Where is that averment?
My lord, in this writ application in paragraph
Petition number 5772.
କୋଉଠି ଆଭରମେଣ୍ଟ ନେଇଛନ୍ତି regarding?
Consolidated କଣ file କରିସାରିଲେଣି ଆଗରୁ?
ଆଗରୁ ଟିକେ knowledge.
Death period.
Yes, କୋଉଠି averment?
In paragraph 6, that against that order, the OP number 2, we filed a revision case 10 of 99 before Member Board of Revenue. Member Board of Revenue was the order dated 18/6/2018 of OA collector on Tahsildar and also order to record the above plot number 692 in the name of the state of Odisha. Against that order, petitioner filed WP.
ହଉ ତ ସେଇଟା next କରିବେ.
That order.
Any objection?
No, ma'am.
All right. Telephone IA number P303 of 2025. This is an application for amendment. For the land council, for the petitioner, land council for the opposite party, land council for the state, the land council for the petitioner, and the land council for the opposite party. So to the state submit and they have no objection to the application for amendment. Considering the submission or going through the government taken, we are inclined to accept the fair in this application. Accordingly, the amendment short form is allowed. Now the bill of amendment shall form the part of the writ petition. Consolidated file kunjan in a file karibe. The land council for the petitioner. So it gets some other
3 days.
3 days. And to file the consolidated.
ଆଚ୍ଛା implement of parties ତା ଦେହରେ ଅଛି?
I don't mind.
ଗୋଟେ କଣ order of implement of parties ଗୋଟେ କଣ ଅଛି? ଦିଟା ଇଏ ଅଛି।
ସେଥିରେ opposite party
ସେଟା ହେଇଯାଇଛି?
ହେଇଗଲା ଯେ appear କର।
ସେଟା ହେଇଯାଇଛି ନା ନାଇଁ ଗୋଟେ କଣ implement of parties ଅଛି ସେଟା dispose of କରିଦେଲେ ହବ ସେଟା କଣ କରୁଛ?
IA number ଗୋଟେ consolidated already file ହେଇଛି.
ନାଇଁ ଏଇଟା ଏଇଟା ହେଇଯାଇଛି।
So this 16272 of 24
What is that?
cause list ଅଛି ଆପଣଙ୍କ ପାଖରେ? So do you, this order has already been passed or you don't want to praise this application? IA number 16272 of 24 at flag E. ଦି ଜଣଙ୍କୁ ଆପଣ ଆଡ୍ କରିବାକୁ ଚାହୁଁଥିଲେ representative capacity of Dakhinabad village.
ସେଟା withdraw ହେଇଯାଇଛି।
Withdraw ହେଇଯାଇଛି, but
dispose of ଲେଖା ହେଇନି ତ କେବେ କୋଉ ଡେଟ୍ ରେ?
yes, let us see that. withdraw ହେଇନି ତା ଦେହରେ order pass ହେଇଥିଲା 17/12/2024 16272 then council on the basis of so and so representative capacity so and so in the meantime
news publication ରେ notice through
of
ଗୋଟେ
direct and she prays for direction
order 1 rule 8 ଆଚ୍ଛା ଆଚ୍ଛା
of the considering so and so putting this court
para section
director to file the draft notice and suggest the name of the newspaper having so and so. And failure of the draft notice so and so appears to be defective. Fresh draft notice be filed. After one, अच्छा समाज में अपन use कर ले division. Notice has been published in the daily newspaper.
OP3 has entered appearance to learn in senior.
So it are not first for you. 16272 of 2024 is an application for so and so. Land council for the petition does not want to press this application as opposite party number 3 has son of deceased opposite party number 3 has already entered appearance to council.
After publication of the notice?
No, my lord, before publication.
Arata? Ara loko jago kare
Three number or 2 and 3 died. Who are the conduct this case as a representative capacity of the villagers. So inadvertently, I have filed an application to implead 2 persons who are the who conduct the case as a representative capacity. That I am 162 of 72. And in that application, your lordships directed me to
newspaper publication. Yes.
Because this petition is not
One publication was defective, so it was not published. Thereafter,
I filed a draft copy, and that notice was allowed. And accordingly, I
yes, that have you published. Thereafter, the sun has appeared.
No, my lord. Before that,
sun had appeared. Since draft notice has already been published.
লেখা is the border লেখা yes I তো এটা প্রয়োগ করব না
Yeah.
We're just coming within 2 minutes.
Such minutes such. Item 2.
Item 25.
For item number 25, on last occasion I had submitted that I have instruction to appear for all substitute legal heirs Miller. But I have only filed my Docklanama for 4C and 4E Miller. I have no instruction for other Miller. Perhaps they don't want to engage me. I am only appearing for 4C and 4E Miller. 4C and 4E. 4D and 4E. C and E Miller.
4C and E.
ରବିନାରାୟଣ ଜେନା ବସନ୍ତ ମଞ୍ଜିଲ ସ୍ୱାଇଁ ଏଇଥିରେ କଣ ହେଇଥିଲା ନା ମାଇ ଲର୍ଡ ରିଟ୍ appeal was dismissed for default. Then CMAPL that your lordship in footnote can find. CMAPL number 817-19 was filed. That was also dismissed for default. Then CMAPL number 492 of 2022 was filed. So thereafter I had pursued the matter. However, in both these CMAPL, respondent for the OP number 4 had appeared. And except these two, others, despite notice, they did not appear. So that is it was allowed and restored. So if you also consider that, or whatever you also decide.
No, if he has no instruction for 4A, 4B, and 4D,
then only way to send the notice. If they don't appear, then
notice has already been issued.
In one CMAPL, I had appeared for 4. During pendency of that CMAPL, 4 died Miller. And thereafter, I am appearing for Miller, E and C Miller. In one CMAPL, I was appearing for C and E.
No, we followed it.
When the matter was taken up on 28/2/2025, you said you have instructions to appear on behalf of all. But now you are saying no.
No.
Achkal notice jibo.
Notice जीवो ना आपण आप already power file कर सारलेनी तो 4C and 4D E ପାଇଁ. So what is your good name and counsel?
Rajesh Ranjan Sahu.
Rajesh Ranjan Sahu. So where is that V number? Let us see. Rajesh Ranjan Sahu, you are appearing for Basanto
Manjari Swain.
Basanto Manjari Swain out of
And Rabinarayana Jena.
Rabinarayan Jena. They are 4C and 4E.
4C and 4E.
All right. Look on this. Though as per IN number 61 of 2025 is an application for substitution of the successor of the legal heirs of the deceased respondent number 4, Jena. When the matter was taken up on 28/2/2025, Mr. Rajesh Ranjan Sahu and counsel submitted that he had instruction to appear in this case on behalf of the legal heirs of deceased respondent number 4 and also undertook to file wakalatnama for the legal heirs. However, he submits that he has filed wakalatnama only for 4C and 4E, namely 4C ta kiye?
Milord Rabinarayan Jena.
Just a minute. 4C Rabinarayan Jena and 3 Basanta Manjari Swain. And he has no instruction so far as 4A, 4D, and 4D are concerned. Issue notice kar do. Issue notice to the so-and-so. Requisites for issuance of
registered post.
By registered post. Be filed by time.
3 days time.
3 days. Matter will be listed for consideration of the interim application.
With postal tracking.
Postal tracking report. We have to update. 4 weeks time we know with postal tracking report.
Miss Mudali is there with you.
He's with me.
Exactly.
4A, 4B, out 4B fine.
Because I am appealing for respondent number 5.
Yeah, just opposite party number 5. What is your good name?
Vivaswat Mahapatra.
Mr. V. Mahapatra.
V. Mahapatra.
V. Mahapatra, land counsel for the opposite party number 5.
Present.
5 is present. Baki land Mr. P. Mahanti, land senior advocate, along with
Yeti Mudali.
K.T. Muda.
OP number 3.
OP number
3.
What is your good name?
Lopamudra Pradhan.
Acha, Mr. Lopamudra Pradhan for opposite party number 3.
Yes.
All right. Yellow charge.
Jala साथ है. Correspondent.
21 तारीख को
Notice जो था उसका.
21st को 21 जारी जी हो गया. Yes.
Item 26.
State appeal. The order of the single judge at page annexure 1 page.
I am appealing for the sole respondent Workman minor. The appeal was filed, the delay is 320 days for filing the appeal.
अच्छा था.
I will file an reply to that.
Objection.
Objection.
You have received the copy.
I have received the copy and appeal.
Writ appeal copy, so also IA copy you have received. All right.
Within a week, madam, I will file.
Have you filed the certified copy? Dispensing of the
Dispensation के आई.
file it.
मैं
26.
No, 26 or 35%.
Would I for dispensing with filing etc.
You are Mr. Tarun Kant Patnaik. Mr. Tarun Kant Patnaik, land counsel appearing for the respondent, submits that he has received the copy of the writ appeal, so also the copies of the interim applications, and since there is a delay of 320 days in filing the writ appeal, he intends to file objection to the which is that IA for condonation.
3691.
Interim application for condonation of delay 3961 of 2020. 3691 2020. What time you require?
Within a week, madam.
Within a week, matter will listed.
This is plus.
2 sabta time dealing. Yes. Last period, objection you can I don't maintain giving copy because I'm counsel. 1 week up.
26.
24. 24. 3/24.
Item 27.
That is all. This CMFL has been filed for restoration of writ appeal number 371 of 2019, which was dismissed for deferred for non-compliance of the peremptory order. This writ appeal order was passed on 16/9/2022 for the issuance of notice, and the requisites were stated that was filed thereafter. But when the matter was again listed on 21/10/2019, as the lawyers were not abstained from court work, a peremptory order was passed, which was not.
Who has entered? You have. Have you filed any objection?
Yes, my friend has filed an
objection at flag C. Yes, Mr. Samudray. What is your explanation for?
Explanation is that peremptory order was passed, but because there was lots of abstention of lawyers from the court work, it was not within knowledge of the petitioner. But however, he had filed the requisites pursuant to the honorable court's order earlier, but that was not on record, so he had no impression that
the peremptory order was passed. When he inquired about the status of the case, he came to know that peremptory order was passed, and consequently, this matter has been dismissed.
No, what about the recusals you had filed earlier? Those are there on record.
So that we had taken government, but 2019, so I think that was not traced out in the record.
No, in the filing counter, if you file anything.
They noted in the register.
Then no receipt was granted.
No, but they noted in the register.
Box रे सेତେବେଳେ ଗଣୁଥିଲେ exact time
2019 ରେ
ଆଜ୍ଞା
ଆରେ ସେ ସବୁ ନୋଟିଂ ହେଇକି ଯିବନି
ଯିବା କଥା ତ ସେ ଯିବା କଥା
ଥିବ ସେତେ ସବୁ ଥିବ
But the only question is that petitioner is a dismissal from service. He should be given an opportunity to place his case. There is a delay of 900 days. Also consider that.
What the petitioner was challenging in that writ petition?
No, disciplinary proceeding, he has been removed from service.
Writ petition result, what was the writ petition result?
Writ petition was dismissed for default. And he had filed a writ appeal against that order for restoration.
This CMAPL was also dismissed for default.
And that you also have been pleased to restore it this CMAPL.
This is the Supreme Court's principle. Not vigilant. Lords may see the judgment. Lords may see the judgment of the Honorable Supreme Court. I am placing that. They have taken the ground that lawyer has not vigilant. The Honorable Supreme Court has stated. The Lords may see.
Is Mr. Sinha in practice?
Yes.
He is practicing.
Para 5 that judgment. There is
question now. Which paragraph?
There is delay of 534 days. The Lordship may see para 5. Para 5. The first appellate court condoned the delay of 534 days in preferring appeal, essentially on the ground that the litigant should not suffer on account of negligence of the part of the advocate.
Who was the litigant in that case? State or
No,
private party?
Not state. The private parties are there.
Rajneesh Kumar.
Yes. Lordship may see that advocate and the court should adopt a liberal approach. The para 6. The respondent here dissatisfied by the order passed by the first appellate court condoning the delay, challenged the same before the High Court. The High Court allowed the civil division application by which order passed by the appellate court condoning the delay came to the cost by the set aside. That was challenged with the Honorable Supreme Court. Para 10, your Lordship. It appears that entire blame has been thrown on the head of advocate who was appearing for the petitioners in the trial court. We have noticed over a period of time a tendency on the part of the litigants to blame their lawyers of negligence and carelessness is attending the proceeding before the court. Even if we assume for a moment that the concerned lawyer was careless or negligent, this by itself cannot be a ground to condone long and inordinate delay, as the litigant owes a duty to be vigilant of its own rights and is expected to be equally vigilant about the judicial proceedings pending in the court initiated at his instance. The litigant therefore should not be permitted to throw the entire blame on the head of the advocate and thereby disown him at any time and seek relief. Thereafter, the Honorable Supreme Court that judgment of Salil Dab and such was quoted, and para 12, the Honorable Supreme Court quoted the necessity of the period of enacting the period of limitation has been and dismissed that. So 534 days delay was also not condoned. Where the the principle.
We have no blame on the lawyers.
Yes. It is the petition.
Mr. Samantra,
In fact, it's not no law. Lawyer is not blamed here. Only question that because there was abstention, so they could not. If petitioner has not put the lawyer, not blame on the lawyer.
There was what?
lawyers abstained from court work. On that day, peremptory order was passed.
So you are not supposed to check what is the order.
No, I don't say that.
Then the lawyer should check what is the order.
Because he had filed the requisite seizure, that's
So
why.
when had you filed the requisites? Give us the date.
That date has been given in paragraph 3 of the petition. 16/9/2019, requisites were filed. Para 3 of the petition.
Paragraph number 4
of the same period.
Yes, same.
The limitation petition IA, para 4(2), but there is no proof to that effect, whether it was filed or not.
এটা কোন ইয়ের ফাইল করতে রিকুইজিটসটা CMAPL
No, writ appeal. In the writ appeal, your lordships are pleased to issue notice. So accordingly, on 12/9/2019, Honorable Court were pleased to issue notice in the writ appeal. Pursuant to order dated 12/9/16/9, these requisites were filed.
ଇଏଟାକୁ ଭେରିଫାଏ କରିଦଉଛୁ ଆ ଭିତରେ 16/9/2019 ରେ ରେଜିଷ୍ଟରରେ ଏଣ୍ଟ୍ରି କିଛି ଅଛି ରିକୁଇଜିଟ୍ସ ଫାଇଲ୍ ତା ଭିତରେ ଆପଣ ଇଏ କରନ୍ତୁ ଭେରିଫାଏ କରିଦବ ନହେଲେ ଏଣ୍ଟ୍ରି ଥିବ ନା IA number 147/2022 is an application for condonation of delays. The stamp reporter has what is the delay shown?
979 days by this stamp reporter.
Why have you said that the delay of 800?
No, I had taken that place, but subsequently delay has been given 979 by the stamp reporter. My calculation may be wrong.
Calculation wrong. ସେଟାକୁ amendment କରିବା ଦରକାର ନାହିଁ ଆପଣ ପ୍ରେୟାର କରୁଛନ୍ତି ଯେ 881 ଦିନର ଡିଲେ କଣ୍ଡୋନ ହବ ଡିଲେଟା ପ୍ରକୃତରେ ରହୁଛି 979 ଦିନର so if that is so how can we condone the delay of 979?
Yes, I'll file an application for the loss.
Amend
that in the meantime, lordship
those things should become the stamp reporter IA number sounds. Stamp reporter has pointed out that there is delay of 979 days. However, in the interim application, the prayer has been made for condoning the delay of 881 days in filing the restoration petition. Mr. Samantrayal and counsel appearing for the petitioner submits that he will file necessary amendment application to this IA for condoning delay of 979 days. Stop. Objection has already been filed by the opposite party number 1 and 2 to the interim application for condonation of delay. The learned counsel for the opposite party has placed reliance in the case of Rajnish Kumar and another, Dev Prakash, order dated to 21st November 2024, passed in Swansea in SLP number Swansea, which is taken on record. In the interim application, in paragraph number 4, government has been taken that this court by order dated 12/9/2019 passed an order in the writ appeal directing the petitioner to file fresh requisites for service of notice on the respondents with further direction that matter will be on the stage on 25/10/2019 and the petitioner complied the said order and the requisites were filed on 16/9/2019, and that the counsel for the petitioner remain under bona fide impression that the writ appeal will be lifted on 25/10/2019 as directed. Stop. There is no documentary proof filed by the land counsel for the petitioner with this interim application to substantiate the averments taken in this paragraph regarding filing of requisites on 16/9/2019. Let the registry verify as to whether in the writ appeal number ta kete
371 of 2019.
writ appeal number 1 any such requisites have been filed by the petitioner on 16/9/2019. Report to that effect will be placed. Matter be listed in the week commencing Keber of your first week of the week 2nd of April 2025. Yes.
Why was the writ application dismissed?
Writ application was dismissed for default loss. Against that, writ appeal was filed.
No. Against that, restoration was filed. That was dismissed on the ground of delay. Against that order, probably you have filed writ appeal.
But so far as writ appeal and writ application are concerned, I think the lawsuit said that so far writ petition is concerned, no delay can be as per rule.
Yes. So it was for restoration of the.
Yes.
So that ground, your writ appeal, you had.
So normally that was the ground.
But again, writ appeal, you have done it again.
But I filed an application for condonation of delay. So
No, that is all right. No, I was looking at that CMPL for restoring the writ petition.
Yeah.
That you are right.
Yeah.
Their delay need not, but you have to explain the delay.
Right.
সেটা আসলে সেটা
2/4/2025. Yes.
Item 28. Right, please, Your Honor. My lords, in item 28, I filed an IA for correction of a typographical error in the order, my lord. Lords, may see page 6 of the IA. Order dated 25/11/2024. The writ appeal was disposed of, my lords, whereas the writ petition was restored. However, the writ petition number is different.
Petition number ta bhul hoichi.
Yes, my lord. It is supposed to be 12819.
25/2024.
Item 15697. 156.
12/18/2021 যেটা হবার কথা গেছে
12819 is the correct number.
IA number
807
of 2025. What is your good name, Land Counsel?
Sunshine Anand Swami.
Please give it in right
My
for the petitioner. Submits that there has been typographical error in the order to date 25/1/2024 and the petition number has been inadvertently mentioned as 1 2 petition number has been mentioned to be 12829 of 2021 in place of 1 এটা ঠিক কেতে হবো
18229
18229
no my lords 12819
तो 19 हब 29 ହେଇଯାଇଛି
ଆଜ୍ଞା
where is allowed the
you served copy on the other side
no my lords I will serve the
serve copy will pass that order but you serve a copy
I will serve the
get a copy of this one to be served on the land council for the opposite party. You are appearing for the in this
appellant
appellant for the respondents, no? Out of this matter in the we commencing from Keber
any date my lord
next
next week 11th one 7th
11 ता काली
oh sorry
17
18th
आज सोमवार तो
हाँ sorry from 17 March 2025 yes
item 29
The petitioner has filed an IA for further proceedings in contempt proceedings number 48 of 2004 filed before the administrative tribunal.
who are you
I'm for the petitioners.
you're for the Union of India
My lord. Okay.
the order was passed in WPC. From the years filed the cabinet petition, the number of you. Gentlemen supplied the okay, let's just matter with the private petition, the name of Swanshu. So your matter notice has not been issued. So,
May I pray, my lord?
yes.
The issue involved in this writ petition is covered to a series of orders and a judgment of this honorable court, which affirmed by the honorable full bench of honorable apex court. Relying upon these orders and judgment, the law tribunal has passed the order. Issue involved whether the in-service training period will be computed as qualifying service for grant of financial operation under MSC scheme. Issue decided yes will be counted as qualifying service for SCP mine. SCP modified to MSCP mine. So similar place person they file a case. When the said period is computed as qualifying service for SCP, MSC being a modified format of SCP, that period may be computed as qualifying service. The Lordship kindly give against the improved order mine. All the judgments and orders of the court relied upon by the honorable tribunal.
No, it's all right. Now it is to become under the heading of admission.
My lord.
Because on that day,
the Lordship only directed for me a copy. Another error, my lord. On the last occasion, I inadvertently I mentioned caveat petition number 256, but that is 219, my lord. Caveat number 219. That part may be corrected, my lord.
The wrong number has been found.
256.
the Mr. Nirmal Ranjan Rao, Land Council submitted that in the order dated 1/8/2024, the caveat petition number has been wrongly reflected to be 256 of 2024. In fact, the correct number is
219.
219 of 2024. So the Land Council further submits that the issue involved in this case is already has already been answered by the Honorable Supreme Court.
This court confirm में honorable apex court में.
Has been
We'll check.
has been confirmed by this court by division bench.
My lord.
By division bench, and which has also been approved by the Honorable Supreme Court. And what is those cases?
My lord, page 1 to 7, the judgment.
1 to 7.
My lord.
So the 256 caveat has to be delinked from this.
Fine.
The caveat petition number 256 of 2024, and in its place 1. So to the current. On the 127, who he?
127 of the what?
Page of read petition, my lord.
Read petition.
What is this judgment?
Lordship kindly give a space. 138 last chopper. On basis of admitted position that the opposite parties applicants have been appointed on pursuant to advertisement so and so, as such, there is no dispute about the fact
No,
that
we are not on that. We are just, he has to address it on the admission. Just what you said that it is covered by some decisions have been rendered by this court, and against that also they have gone to the Honorable Supreme Court, and the Honorable Supreme Court has also taken that. So this is the judgment of the High Court.
Mine.
Okay. That is your High Court. Judgment of this court, a division bench of this court, which has been annexed as annexure A by 11
to the OMI,
to the original application at page number 82. The number would have listed.
Annexure A by 11.
11.
Page 82.
Sir, my lord, page 127. 82 out page number.
WPC number 1 which is annexed to as annexure A by 11 to the IA available in page number 8. And the Honorable Supreme Court decision.
Page 145, my lord.
And page number 145.
The series of special.
Just a minute. 145. It was confirmed by the Honorable
Supreme Court. On page 147.
It was confirmed by the Honorable Supreme Court, which should be evident from the order dated. 22/10/2019 passed in so and so case number specially petition number annexed as annexure A by 30 the original application. Page number but for page of 145 the land council for the petitioner submits that the matter may be taken up for admission next week.
My lord, contempt proceeding my learned friend has filed. That is 48 of 2024, and order is about to be passed. The lordship may ask to not to proceed with that order.
Contempt petition posted to May, my
lord. Your lordship may say till next date.
No, next. I'm talking next week, right?
Yes, my lord. Till then,
content petitions are made. We are taking up this matter next week. So why
my lord, in this 13th that is there in March 13th.
12,
No, my
13,
lord,
14 is
this
holiday
month
of
that
cash.
is, I am
Right.
confirmed, my
If
lord.
it is 13, why are you saying May?
My lord, I'm saying 13. 13th is a holiday of
No,
cash.
no, I am confirmed, my lord. In
We
this
can
March
check up.
that is
We can
pending.
check up.
Okay.
Put up this matter next week, dot the reporting, 10th March, 2020.
Aji 10 पर.
Aji do.
Aji das, hey, sorry.
19th May.
13 तक वो holiday. 13 पर Friday.
Cat holiday.
अच्छा,
Cat holiday vacation.
So 19th.
17.
17. Yes.
Your lordship may only say if I will file a adjournment petition that
I am no objection. I will not proceed well with the contempt. I am oral submitting before my.
The Lion Counsel for the petitioner submits that a contempt petition has already been filed before the Central Administrative Tribunal, and the matter is likely to be taken up during course of this week.
Listed shortly.
Listed shortly. However, the Land Counsel for the opposite party submits that at present he will not pursue the contempt petition, which is sub judice. That's all. Yes, next.
My lord, my name may be noted. My appearance may be.
ଆପଣ କଣ ଆପଣଙ୍କର
Senior panel counsel.
senior panel counsel?
Yes, ଆପଣ ଦେଇଛନ୍ତି appearance memo ଦେଇଛନ୍ତି?
Appearance memo you file? You have to file the appearance memo.
ୟାଙ୍କ ନାଁ କଣ ରହିବ ନା କଟିଯିବ? ନାଇଁ ମ ବୀରେନ୍ଦ୍ର କୁମାର ପାଢୀଙ୍କ ନାଁ
Previous council may be deleted.
ଆଚ୍ଛା ତାଙ୍କ ନାଁ ତାହେଲେ କାଟି ଦିଅନ୍ତୁ ହେଲା। The name of Mr. Virendra Kumar Padi shall not be reflected in the project and in its place also shall be reflected.
You will file appearance memo today?
I have filed.
Already filed. All right.
Obliged.
Item 30.
These are matters which the Honorable Supreme Court remitted back. I'm just showing one order of the coordinate bench where also it was remitted back. That's a writ of fees. Your Lordship may kindly see the question which the court has formulated for the state to answer. The same question arises here, that whether the ASO could have gone beyond the orders of the ATM. That's order dated 24/2/25. Recently, coordinate bench has passed it. And the state
from Mr.
The coordinate bench, I'm giving that, given that. The same question arises in item 30 and 31, that whether ASO could have traveled beyond the orders of the ATM. And relevant para would be paragraph 4, 5, and 6. The state has taken time to show how ASO could go beyond the orders of the ATM. Paragraph 4 would be very important. What's more important is that the ADM had granted lease in favor of the petitioner's vendor in these two cases pursuant to the orders of this court. The Lordship wants, I made a convenience compilation, which is at flag A, where all the orders are a part of your Lordship's records.
But the
And Lordship has granted to order dated 12/2/2025. And Lordship has passed the order on 12/2/2025.
That's regarding limitation. We have taken in
That is the regarding the instruction and the as per the Honorable Appellate Court order, each and every case should be
no,
the merit of the case.
Yes.
No, we will go there. That will not.
And here in this case, my lord, that is the some procedure is there that has not been.
That also the Honorable Supreme Court has.
Yes, that's why, my lord,
it should be
the Apex Court has directed
So, no,
to remand back to.
we have the last order it says, Mr. Mishra,
regarding
you took some
limitation.
time to about the status of the appeal, which has been preferred before the in challenging the order dated so and so.
Yes, that we have got. We are filing an affidavit regarding what has happened in limitation.
No, about the status of the appeal.
Appeal was dismissed on the ground of limitation.
Let us see.
But we have given that by way of affidavit, we are giving the entire exact status. Paragraph 2.
And you have given a copy to.
Copy. Paragraph 2, we have mentioned the appeal number. And the appeal, my lords. Appeal memo is there at page 5, annexure 7. And the order passed by the appellate court, my lord, may kindly see. That is at page annexure 8, page 9. 8/8/2013, the appeal is registered, and on the same day at 3:30 p.m., it is rejected on the ground of limitation.
And if it has been rejected on the ground of limitation, those grounds have not been taken in the writ petition. So there is a.
Should you not amend it?
Yeah, it has not been amended.
No, I have not amended it. This was not known to us.
No, now since it is known to us, by filing this thing, it would not do, Mr.
All that, I wanted to draw your attention that this is the status of the appeal.
No, it's all right.
So your appeal is maintainable, but you need necessary amendments. Sorry, your writ petition is maintainable, but necessary amendments are required.
Is there? I think the another section is there for the review or something that
for revision.
That is also stated in that decision. Where is the decision of the Honorable Supreme
Court? That would be at the.
Have you got that decision of the Honorable Supreme Court?
It's a part of your Lordship's record. At flag 10, it must be there. I had shown it earlier. It's not flag 10.
Well, that is perhaps 15B.
15B.
Now, survey and settlement.
Let me see on that. What I was trying to indicate before your lordships is that there will be two kinds of cases. One would be where, pursuant to the orders of the High Court, the ADM grants lease, a full-fledged lease, and thereafter his subordinate cancels it. Those would be cases which are wholly without jurisdiction, and a series of judgments in that light have already been passed. All that the Honorable Supreme Court says is you examine
each case individually
on its own merits. Now, in writ appeal, because there were some orders passed in writ appeal which were also a part of that common judgment. Writ appeal, now the courts has posed a pointed question to the government, saying that you show how the ASO got the power.
That means should these cases not be heard together?
That can be, but then the assignments are all different.
Assignment different, you Supreme Court
ନାଇଁ ନାଇଁ ଅଲଗା ଅଲଗା ଶୁଣା ହବ ନାଇଁ ନାଇଁ ଆରେ heard together ହବାକୁ ପଡିବ ନହେଲେ ତ conflict ହେଇଯିବ they may pass separate orders but should be before one bench ନା ସେ ଗୋଟେ type ଦେବେ ଏଠି ଗୋଟେ type ଦବ.
That would be an issue with
What, Mr. Mishra, this should be brought on record by way of an amendment in the petition.
the petition needs to be amended in view of this.
Right. An additional affidavit has been filed by the petitioner, which indicates today in court, for example, which indicates that against the order passed by
assignment to this court.
the
government land settlement is
You
assigned
know
to this
that writ appeal
Coordinate benches.
because ultimately decision will be I mean as after the remand of the Supreme Court but
court. Whether that writ of that is the remanded case.
If it can be categorized, cases which are wholly without jurisdiction need to be dealt with in a different manner. Cases which have not gone the regular route of appeal, they may have a different kind of
Assistant Settlement Officer
Categorize all
Camp
cases
Bhubaneswar,
from those lines.
and the appeal was referred under section 22(2)(b) of the Orissa Surveillance Unit. Is it 22(2)(b)? Let us see. 22(2)(b), section 5.
22(2)(b).
And the against the order passed by the assistant settlement officers so dated 31/5/2013. Appeal was preferred before the additional sub-collector Bhubaneswar.
On 8/8/2013.
No, you have filed the appeal on 37/2013.
He registered
registered it on 37/2013, and it was taken off on 8/8/2013, and on the ground of limitation, same was dismissed on the very day. The Land Council has annexed the appeal memo as Annexure 7, and also the order passed in the appeal case number 1437 of 2013 as Annexure 8. The additional affidavit is taken on record. During course of argument, Mr. Mishra and Senior Advocate submits that amendment has to be carried out in the writ petition, and therefore some time may be granted to file an interim application for amendment. Put up this matter. How much time you want? Just
3 weeks.
Put up this matter on so that when the case is interim application, if any, we filed in the meantime, giving copy to the Land Council for this state. You have received this copy, additional affidavit today. The copy of the additional affidavit has been served in the Land Council for the state in court today. At the item on the Mr. Mishra has also placed before us an order passed by coordinate bench in writ appeal number 139 of 2023, order dated for the 24/2/2025. And wherein the
5-6 quote କରିଦେଲେ ହୁଅନ୍ତା।
wherein in paragraph number 5 and 6 it has been observed as follows for the quote for that. তারপরে এটা বলছি এটা হচ্ছে yes.
Next factor is similar. Appeal status is also similar. We are giving additional affidavits also, but the numbers would change. And the order date, same day disposal on limitation.
মানে গোটে ডেটে ফাইল হয়েছি সেই
Same. Same, but my lord may see the order at and page 9. It is slightly there's no notice, nothing. It's blank. But similar fate. Same day filing, same day taken up, same day dismissed on limitation. Page 9 of that affidavit.
No notice means it is your appeal.
Now let me see the first order.
Yes.
The blank portion.
If you notice. Acha, that must be the format. But since you are the appellant, without hearing the respondent, it has been dismissed.
It has been, but what these people say that they say that you don't waste your time here. You go wherever you want. We will not. In fact, it's also a part of the records we have given. Your Lordship may remember that two ASOs had come before this court and had sworn an affidavit. That also we have brought it to your Lordship's notice at flag A. That compilation, if your Lordships would see, where they had said that this was being done at the instance of one bureau.
But again, the Honorable Supreme Court has also
individually
that
yes.
We are to
individually. I'm just saying
whether that 15B has been the petitioner has taken recourse to that 15B or not. There is also another against that appeal. Perhaps they are referring to that.
That question is there. That alternative remedy, whether that would be a bar or not. But there, I have come prepared with a series of judgments. One would be that suppose the order is wholly without jurisdiction, then the High Court can certainly entertain.
No, this 15B, it says that on the application made within 1 year from the date of final publication under section 12B, the revision of here final publication has been made.
Has been made.
So when it was made?
Those details will have to. I cannot offhand submit it.
Since the order is very clear, so we have to be also look into it.
That's one aspect. That's one, whether alternative remedy would be a bar in these cases. But then the question here would be that the ADM granted lease
we are not
direction of this court. So it may be a contempt also. What the ASO has done is borderline contempt. 2 writ petitions, 2 times we succeeded. Then the ADM granted us lease. ASO is his subordinate. So he had gone for regularizing. Instead of regularizing.
So we can record your submission that you have not taken recourse of this revision before the Board of Election.
Yes.
The Mr. Mishra and Council submits that the petitioner, after disposal of the appeal, has not taken recourse to the revision power which is available under section 15B before the Board of Revenue.
There is a small submission
yes.
At this point. There are 2 revision provisions in the Sub and Settlement Act.
Yes.
2 different provisions.
Which one?
One under section 15 and one under section 25.
So the
Supreme Court says 15.
Supreme Court says about.
It depends, my lord. The objection is taken at what stage? If the objection is a 22B objection, then the revision will land to 25, not under 15.
22B.
2B. is where the objection has been taken in this particular case. One is, my lord, obligation of final ROR, and one is, my lord, settlement of rent roll. So 22(2)(b) objection is settlement of rent roll.
Here 22(2)(b).
That means, my lord, the revision will lie under 25.
Acha. Acha. Say revision ta hochi, right? You are right. That against that the revision lies under section 25.
Again, my lord.
On its own motion, on acha. Final publication. କାରଣ ୟା ପରେ 22 ପରେ ଆସିଯିବ 23 ଷ୍ଟେଜ 23 ଅର୍ଡର ଏଗେନଷ୍ଟ ରେ ଆସିବ 25 ଆଚ୍ଛା ସେଇଟାକୁ କାଟି ଦିଅନ୍ତୁ 15(b) ଟାକୁ କାଟି ଦିଅନ୍ତୁ କାଟି ଦେଇକି ଲେଖନ୍ତୁ 25 ହେଲା of the Odisha Survey and Settlement Act 1958 अच्छा जो 22(1) ब्रैकेट रखिबे जो b 1 ना ସେଇଟା ଯୋଉଟା ଲେଖିଥିଲୁ ହେଲା ଏ ପ୍ରୋଭିଜନ ଟା ଠିକ ସେ ଦେଖିବେ जो से 15(b) टा जो लिखा है जी मतलब से ऑर्डर दैट इज नॉट करेक्ट एक्चुअली इट 15 स्मॉल बी होगा है सेटा होते कैपिटल बी ऑलराइट एनी अदर matter Mr.
Only two matters same similar orders the numbers would change.
Okay, that is there.
Here also 3 weeks your same date you know. We are grateful to you.
Item 69. It may be urgent to another date because the transfer brief that I received.
69 କିଛି ନାହିଁ item.
Very good.
Can you pardon mention
No item 69.
Accused in jail custody more than 11 years.
Please give it.
In this case, my lord, for accused, two accused released on bail and accused in custody more than 9 years.
I have also similar threat, 2 criminal offense more than 5 years in custody.
Has already had the matter. 302 matter. Yes.
Bail orders କିଛି ନାହିଁ bail orders କିଛି ନାହିଁ yes
Yes. We have not heard this matter.
To some extent, your lordship, 1 to 4 direct witness, your lordship has directed me.
I have not heard.
No,
So this
because
handwriting is not mine.
this is also not my handwriting. Please the matter. Please come to the FIR.
Man.
Here, how many appellants?
One single collect.
And he has been found guilty under section 302. Name is Bharat Sahu.
Man. That's 15 minutes.
FIR is at page
Page 15.
page 15, my lord. 15. Wait a minute.
Have you prepared a date chart or a note?
Yes.
Is there?
Read the FIR.
Lord, ମୁଁ ରାମେଶ୍ୱର ସାହୁ ଶ୍ରୀ ମୁଖୀ ସାହୁ ଆଜି
Rameshwar Sahu is period 1.
ମାଇଲ
Here.
ଆଜି ତାରିଖ 13/6/2024 9:03 ମୋର ରିପୋର୍ଟ ଦଉଛି ଯେ ଆଜି ସକାଳୁ ମୋର ମୋ ଭାଇ ଚୁମନ ସାଙ୍ଗରେ ସୀତାପୁର
Chuman is the deceased.
ଚୁମନ ସାଙ୍ଗରେ ସୀତାପୁର ବନ୍ଧକୁ ମାଛ ମାରିବା ପାଇଁ ଯାଇଥିଲୁ। ମୋର ଭାଇ ଚୁମନ ଆମର ଭିଣେଇ ଶତ୍ରୁଘ୍ନ ସାହୁକୁ 5,000 ଟଙ୍କା ତାର ଝିଅ ବାହାଘର ପାଇଁ 3 ବର୍ଷ ତଳେ ଧାର ଦେଇଥିଲେ। ଯେତେ ମାଗିଲେ ମଧ୍ୟ ସେ ଫେରାଇ ନଥିଲା ଏବଂ ଆମ ସହିତ ଝଗଡ଼ା କରୁଥିଲା। ଗତ ଗୁରୁବାର ଦିନ ତାଙ୍କ ଜମିରେ ଚୁମନ ଶତ୍ରୁଘ୍ନ ସାହୁକୁ ସେଇ 5,000 ଟଙ୍କା ମାଗିବାରୁ ଶତ୍ରୁଘ୍ନ ସାହୁ ଆମକୁ ନେବୁ ବୋଲି କହିଲା। ମୋର ଭାଇ ତା ଘରକୁ ଯିବାରୁ ଶତ୍ରୁଘ୍ନ ସାହୁ ତାକୁ ଚାଷ ସମୟରେ ପଇସା ମାଗିବାକୁ କହି ଟାଙ୍ଗିଆରେ ମାରୁଥିଲା। ମୋର ଭଉଣୀ ମଝିରେ ଆସି ମନେକରୁ ଟାଙ୍ଗିଆ ଚୁମନ ହାତରେ ବାଜିଲା। ଚୁମନ ସେଠାରୁ ପଳେଇ ଆସିଲା। ଆଜି ସକାଳୁ 9ଟା ସମୟରେ ବନ୍ଧ ପାଖରେ ଚୁମନ ଓ ହାତୀରାମ ସେଇଥିପାଇଁ ପାଟିତୁଣ୍ଡ ହେଉଥିଲେ। ପ୍ରାୟ 9ଟା ସମୟ ଆଜି ସକାଳୁ ପ୍ରାୟ 9ଟା ସମୟ ଦିସ୍ ଇଜ ଏ ପ୍ରାୟର ଇନସିଡେଣ୍ଟ। 9ଟା ସମୟରେ ବନ୍ଧ ପାଖରେ ଚୁମନ ଓ ହାତୀରାମ ସେଇଥିପାଇଁ ପାଟିତୁଣ୍ଡ ହେଉଥିଲେ।
ହାତୀରାମ କିଏ?
ତାର ଆଉ ଜଣେ ଆଜ୍ଞା one of the ପାଟିତୁଣ୍ଡ ସେଇ ସମୟରେ ଭରତ ସାହୁ ସାଇକେଲରେ ଗୋଟିଏ ଟାଙ୍ଗିଆ ଧରି ଆସିଲା। ଭରତ ସାହୁ ମାନେ
ନାଇଁ ବୁଝିଲି ଯେ ଆପଣ ତାଙ୍କ ଭେଣୀ ନା ହେଲା
ଶତ୍ରୁଘ୍ନ ସାହୁ।
ଶତ୍ରୁଘ୍ନକୁ ଦେଇଥିଲା ଚୁମନ ପଇସା 5,000 ଟଙ୍କା ତା ଝିଅ ଫେରିଲାନି, ସେଥିପାଇଁ ତାଙ୍କ ଭିତରେ ଝଗଡା ହେଲା। ଶୁଣ ତାପରେ ସିଏ
Mr. Tripathi, who has prepared the note? You have prepared. Okay.
My lord.
ସେଇ ସମୟରେ
ଭରତ ସାହୁ ସାଇକେଲରେ ଗୋଟିଏ ଟାଙ୍ଗିଆ ଧରି ଆସିଲା ଓ ଚୁମନକୁ ଡାକିଲା। ସେ ମଧ୍ୟ ଚୁମନ ପାଖକୁ ଟାଙ୍ଗିଆ ଧରି ଆସି ବନ୍ଧ କୂଳରେ ସବୁବେଳେ ପଇସା ମାଗୁଛୁ କହି ତା ବେକକୁ ଟାଙ୍ଗିଆରେ 4-5 ଚୋଟ ଦେଲା। ସଙ୍ଗେ ସଙ୍ଗେ ବହୁତ ରକ୍ତ ବାହାରିଲା। ଚୁମନ ସେଠାରେ ମରିଗଲା। ମୁଁ ପାଟି କରି ଭାଇମାନଙ୍କୁ ଡାକି ଫାଣ୍ଡିକି ରିପୋର୍ଟ ଦେବା ପାଇଁ ଆସିଲି।
How Bharat Sahu is related to Shatrugna?
Shatrugna is the brother of the Shatrugna.
Brother of the Shatrugna. Yes. Bharat is the brother of Shatrugna. ଯାହାକୁ 5,000 ଟଙ୍କା ଦିଆଯାଇଥିଲା। ଆଉ ସେ ଶତ୍ରୁଘ୍ନ ହଉଛି ଚମନର ବ୍ରଦର ଇନ୍ ଲ।
Hiram is also the brother.
ହାତୀରାମ ମଧ୍ୟ ଚାରି ଭାଇ।
ହାତୀରାମ କିଏ?
ହାତୀରାମ ଯୋଉ ଲେଖିଲା ଯେ ଚୁମନ ଆଉ ହାତୀରାମ ଯୋଉ ପାଟିତୁଣ୍ଡ ହେଇଥିଲେ।
ଆଚ୍ଛା। ସିଏ ବି ଆଉ ଗୋଟେ ବ୍ରଦର ଆର ଶତ୍ରୁଘ୍ନ। Human that died at the spot. So there are eyewitnesses.
1 to 4.
1, 2, 3, and 4.
Four, man.
1, 2, 3. And who is the doctor? Doctor, my lord. 8. 8. So first you come to the doctor's evidence. Let us
34. Page 30.
Chop wound of the occipital region, chop wound on the below injury number 1, chop wound on the neck, that side neck, chop wound on the again injury number 1 on left side, chop wound on the right scapula, chop wound on the right upper arm. So 6 chop wounds have been caused. So injury on the head is sufficient in ordinary course of nature to cause death. All the injuries are antemortem in nature. Cause of death is due to hemorrhage, inside brain and real wounds. So, now you come to the evidence of the witness PW1. He is the informant.
I am the informant. The deceased Suman Sahu was my brother. I know accused Bharat Sahu of village Sitapur, which is about 1 kilometer from the village Gharabandi. Last year, one day in the month of Jester, on a Sunday, I, along with my deceased brother Chuman and another brother Vikram and Devaram Rana of our village, had been to a tank at village Sitapur to catch fish. At about 9 p.m. near near Sitapur tank, the deceased and Hathi Sahu, brother of accused Bharat, quarreled as Hathi took exception why the deceased was always demanding money he had advanced to Shatrughan Sahu, the brother of Hathi. The accused Bharat came there riding a cycle, putting a tangia on the cycle, parked the cycle on the embankment of the tank, put off his shirt, pushed towards rushed towards the deceased carrying the tangia and dealt blow on his back and back of the neck when the deceased was standing near the water of the tank. I am remaining on the other side of the water of the tank, which was about 100 feet. Saw the incident.
Back of the neck. এটাকে বেশি বুদ্ধি।
I remaining on the other side of the water of the tank, which was about 100 feet, saw the incident. I rushed towards my deceased brother and found him dead. The accused ran towards his house carrying the tangia. I ran to my house, got a report scribed by Biranchi Sahu, the son of my maternal uncle, who came to our house on a visit and lodged that at Visatapur outpost. I cannot identify the tangia, which was the weapon of offense, as I witnessed the incident from a distance.
So that tangia was also seized at your instance?
No, man. After the incident, I went to the police station and with that tangia.
So PW7 kept it and handed over to the police.
Yes.
Tangia, because tangia re human blood origin ro A group medici.
PW5 and 7 say about the seizures.
So what you have elicited in the cross examination?
Cross-examination only, my lord, there is nothing. My lord, it is a fact that Shatrughan was not returning the money taken from the deceased. Both of them were quarreling frequently whenever the deceased demanded money. We 5 brothers, including the deceased, are living separately in mess and property. Sitapur tank is an irrigation tank meant for irrigation. The agricultural hands around it constructed by the government. On the date of incident, the water was slowly coming to the tank due to pre-monsoon rain. There was chest deep water in the tank. At the time of incident, it was raining mildly. We are catching fish at different places of the tank. We had carried one fishing net. It is not a fact that Ulysses and Hathi did not quarrel near the tank. They were exchanging words. The deceased remaining near the water of the tank and Hathiram on the embankment of the tank. Due to assault, there was a profuse bleeding, and the earth near the water of the tank became stained with blood. Near the place of incident, there was a omori plant. It is not a fact that I have not stated before the police that soon after the incident, I rushed to the deceased and found him dead. That I came to my house and I got a report scribed by Biranchi Sahu, the son of my maternal uncle. At the time of incident, the water was not flowing from the bank through its outlet. That tank was in a slanting position and the incident took place on the lower part of the tank. The embankment of the tank would be about the height of the two-person. There is a tank in our village, Dhanara Bhat. It is a fact that most of our villagers is using the tank in our village for bathing. It is not a fact that 2 to 3 days prior to the incident there was heavy rain. There is no steps to reach the outlet. It is not a fact that I have not started before the police that the accused assaulted the deceased by running to him. It is not a fact that I have not witnessed the incident and deposing also.
You see, the quarrel which was happened on that particular day, that was between the deceased and the Hathi Sahu. Hathi Sahu is the brother of that deceased brother-in-law, right? So you were nowhere in the picture. No. You came all on a sudden with a tangia and started assaulting the deceased, giving number of blows on different parts of the body, including neck and also head, which proved fatal. So you have placed the cross-examination. What is your submission? That
my submission, my lord, your lordship, there is a quarrel between the deceased and that Hathiram.
Yes.
Since, my lord, the deceased has quarreled with the brother of the present petitioner, my lord. As a sudden quarrel, my lord, sudden provocation, my lord. He has
no. Deceased was quarreling with
Hathiram.
My lord. Deceased was not quarreling with you.
No.
They were just quarreling, and this Hathi was asking that why are you demanding money from my brother, which he had, of course, advanced for a particular purpose, and since 3 years back, he is not returning. You were not there at the place of quarrel at that time. You came in a cycle with a tangia, parked the cycle, and then rushed towards the deceased and assaulted. So in that way, how do you see that?
My humble submission, seeing that quarrel between the deceased and the Hathiram, I was provoked and assaulted my humble submission. Since they are assaulting my brother, my lord. They are quarreling with my
brother. Assaulting.
No, quarreling with my brother.
Has Hathiram sustained any injury? He has not sustained any injury.
Quarreling with each other, my lord.
That's all right.
For that reason, my lord, I have assaulted.
No, somebody was. That is not the. That would not come within.
Under the matter for ye. Exception.
It cannot come within.
No.
So
No exception.
which exception it would come? There are maximum 2 exceptions would be there in a situation. Exception 1 and exception 4. But this should not be applicable to you. 300, you come to section 300 and 300 exception 1 says culpable homicide is not murder if the offender, while deprived of the power of self-control by grave and sudden provocation, causes the death of a person who gave the provocation or causes the death of any other person by mistake or accident. So there is no question of grave and sudden provocation of
Yes, sir.
You are nowhere in the picture. And exception is that the provocation should not be sought for or voluntarily provoked by the offender as an excuse for killing or doing harm to a person. And so your brother was asking the deceased as to why you are frequently
asking for money.
asking for money. That's all, because he is not demanding any money. He has given that money. He is asking for that money, and since last long 3 years, that was not being repaid. That is the prosecution case. So you came and started assaulting. And exception 4 also says that culpable homicide is not murder if it is committed without premeditation, in a sudden fight, in a heat of passion, upon a sudden quarrel. So these are not there here, totally absent. You are suppose, let us say, during the course of quarrel between this deceased and your brother, something would have been done by S.K.Sahoo. The matter would have been different, let us say. But you are not the S.K.Sahoo. You are a brother. You came subsequently. So your case would not come within these exceptions. And once these exceptions 1 and 4 would not be attracted, your case would not come within culpable homicide not amounting to murder. So then only remains is murder. And that apart, the number of blows and the parts of the body you have selected in assaulting the deceased. Those are you are holding a sharp cutting weapon. You are using that sharp side, and you are causing chop wounds on the right side occipital region. Again, another below that. Hard blow is on the neck. Fourth blow is also on the left side of the occipital region. Fifth is on the right scapula. Sixth one is on the right upper. So all these injuries you have caused. And nothing has been brought out in the cross-examination that
there is a sudden provocation or
and similar evidence has been adduced by
all men 1, 2, 3, 4.
2, 3, and 4. All of them have stated that what was between the deceased and that Hathira.
They are fishing in that river pond, madam, and they have stated that they have seen the incident that the present petitioner has assaulted. All men.
And all of them have also stated that you dealt 4 to 5 blows with a tangia and fled away swans.
Towards the house.
And the deceased died at the spot. That is also stated. Who are the other witnesses? Apart from this 1, 2, 3, 4 are eyewitnesses. 8 is the doctor. What about 5?
5 the
seizure of the tangia. I found the accused who was carrying a tangia inside the house. Police called me. For that tangia, that means it was seized from your possession.
I went to the police station and handed over the tangia.
7.
7
is the manner that constable.
Constable, same thing.
Same thing.
He committed so and so, produced tangia from the hand. And the C report is at page number 43 of the paper,
human draw,
which indicate that the tangia with the handle, it contains blood and it's a human blood, and the group is A. And the check and other lungis which has been seized, those are of the deceased. That would be that would appear from page number 41. Check lungi, red towel, and blue banyan. Those are of the deceased, and those were also this group blood is A. So that means the blood which was found
in the accident.
In that Tangia is also the group blood group of
A1.
the deceased, right?
Yes.
And what is your defense plea?
Defense plea are totally absent.
विरोधी पार्टी मुझे फंसे दिला. Since how many years you are in custody?
No, after 10 years, the present petitioner was released. On the date of 2004, I was arrested. After that,
You are being granted bail by this court?
Yes.
By which order? Huh?
2014.
କେବେ?
2014.
2014 ରେ. अच्छा. 11/8/2014.
और 13/6 arrested the accused. I go to page 38 of the paper book.
ଆମେ ଲେଖିଛୁ ମଧ୍ୟ 11/8/2014 ଲେଖିଛୁ. Arrested on 13/6/2004. So yes, Mr. Pradhan, what do you say?
No other intention except murder. The intention.
Please take your seat.
One other thing, lastly, your lordship has seek the status of the appellant, madam. Now he is residing doing labor work, madam. And during the period of madam that his conduct is also good, madam.
No, it's all right, but that is a different matter. But we have to decide the future. Unless we decide to alter the conviction to any other offense, those things would be immaterial. Right? Look on JCLA number 76 of 2006. The appellant, S.K.Sahoo face trial in the court of Session Judge Kalahandi Nuapada, Bhavani Patna, in Sessions case number 112 of 2004 for offense punishable under section 302 of the Indian Penal Code on the accusation that on 13/6/2004 at about 9 a.m. near Sitapur Tank, he committed murder of human Sahoo, bracketry hereafter the deceased. The Lennon Trial Court by judgment and order dated 10th August 2006 found the appellant guilty of the offense charged and sentenced him to undergo rigorous imprisonment for life and to pay fine of rupees 20,000 in default to undergo RI for 1 year. The prosecution case, as per the first information report lodged by PW1 Rameshwar Sahoo on 13/6/2004 before the officer in charge of Lanjigad police station. In short, is that on that day, in the early morning, he, along with his brother, along with the deceased, who was his brother, had been to Sitapur pond to catch fish. The deceased had given a sum of rupees 5,000 to his brother-in-law, Shatrugna 3 years prior to the date of occurrence, on the eve of daughter's marriage of the said Shatrugna. Shatrugna was not refunding the amount and to the deceased. Over this issue, there used to be quarrel between them. तो गुरुवार लिखी माने केबे जो माजिल हाँ घटना को जनाला 13/6/2000 Sunday. At the 3 days prior to the occurrence, the deceased asked Shatrugna to refund a sum of rupees 5,000. Who told him to come to the house to receive the same. When the deceased went to the house of Shatrugna, he was assaulted with a tangia. The sister of the deceased intervened and the tangia blow hit the hand of the deceased, and thereafter the deceased came back. On the date of occurrence, that is on 13/6/2004, at about 9 a.m., a quarrel ensued between the deceased and Hathiram, who is one of the brothers of Shatrugna, relating to the repayment of rupees 5,000 which the deceased had given to Shatrugna. Stop. At that time, the appellant came in a bicycle with a tangia and called the deceased and assaulted him with the tangia on his neck and other parts. It did 4 to 5 blows on the neck and other parts. As a result of which the deceased died at the spot. The informant, bracketary PW1, called his other brothers and Thereafter, the first information report was lost. PW9 subpara. The officer in charge of PW9 na likh diya. Dheeraj Kumar Chopdar, the officer in charge of Lanjigarh police station, on receipt of the first information report from PW1, registered Lanjigarh PS case number 20 dated 13/6/2004 under section 302 of the Indian Penal Code against the appellant, and he himself took off investigation of the case. Stop. During course of investigation, he examined the witnesses, visited the spot in village Sitapur, held inquest over the dead body, and prepared the inquest report Exhibit 5, sent the dead body to the medical officer, Lanjigarh Government Hospital, through constable for post-mortem examination, and he also seized one green Hercules cycle, a pair of Hawaii chappals, black check shirt lying on the embankment of the pond as per seizure list Exhibit 8. He seized the bloodstain earth sample R and amari leaf stained with blood lying near the dead body as per seizure list Exhibit 9. On the date of occurrence, he also arrested the appellant, and on the production of the appellant, the Tangia bracketry MO1 was seized under seizure list Exhibit 1. The appellant was sent for medical examination. His wearing apparels, the wearing apparels of the deceased were seized on being produced by the escorting constables under seizure list Exhibit 10. And the seized articles were sent for chemical examination to RFSL Berhampur on 16/7/2004 to the Lenin SDGM Bhavani Patna, and the chemical examination report by Exhibit 13 was received. The IO also made a query to the doctor bracket PW8 who conducted post-mortem examination regarding possibility of injuries found on the deceased with the seized tangia, and the query report was submitted by the doctor, and on completion of investigation, PW9 submitted charge sheet under section 302 of the Indian Penal Code against the appellant. Next para. After submission of charge sheet, the case was committed to the Court of Session after complying due procedure, where the Lenin Trial Court framed charge as aforesaid against the appellant, which the appellant pleaded not guilty and claimed for trial, and accordingly the sessions trial procedure was resorted to establish his guilt. The defense plea of the appellant is one of denial, and he has taken a specific plea that his political opponents have falsely entangled him in the case. And he has also denied to have produced any tangia before police. In order to prove its case, the prosecution examined 9 witnesses. The prosecution also exhibited 14 documents, the details. It also proved 5 material objects details. The London trial court, after assessing the evidence on record, came to hold on the basis of evidence adduced by PW8 and the post-mortem report that the deceased died a homicidal death. The London trial court accepted the evidence of the eyewitnesses PWs 1 to 4. So also the production of Tangia bracketry MO1 as deposed to by PW4, PW7 and PW9 and came to hold that the medical evidence corroborates the version of the eyewitnesses that the appellant dealt several blows by Tangia MO1 to the deceased. The London trial court also took into account the chemical examination report finding that the Tangia bracketry MO1 was having human blood of group A, which was the blood group of the deceased, and it was held that the appellant had no other intention except the intention of causing the murder of the deceased, and accordingly found the appellant guilty under section 302 of the Indian Penal Code. Mr. Amitabh Tripathi, Land Counsel, appearing for the appellant, though has not disputed that the deceased died a homicidal death, but argued that it appears that there was some quarrel at the time of occurrence between the deceased and S.K.Sahoo relating to the non-refund of amount of rupees 5,000 which was given by the deceased to Sahoo, the brother of S.K.Sahoo. And during such quarrel, the appellant seems to have been provoked and assaulted the deceased, and therefore the case would not come within the purview of section 302 of the Indian Penal Code, and it would be a case of culpable homicide not amounting to murder. The Mr. Sharat Pradhan, Lenin, Additional Standing Counsel, on the other hand, supported the impugned judgment and submitted that the evidence of the 4 eyewitnesses are very clear and nothing has been brought out in the cross-examination to dislodge their version, and the version of the eyewitnesses gets corroboration from the medical evidence adduced by PW8, who has seen number of chop wounds on vital part of the body of the deceased. Moreover, the evidence on record is very clear that it was the appellant who produced the tangia in the police station, which was seized by the IO, and that tangia was also sent for chemical examination, and human blood of group A was noticed on it, and therefore uh, the it can be said that the prosecution has clearly established the guilt of the appellant. The Land Council further argued that since the quarrel was between the deceased and Hathi Sahu, and the appellant was nowhere in the picture, and he came to the spot with a tangia and mercilessly assaulted the deceased, there was no question of grave and sudden provocation of the appellant in the factual scenario, and therefore his conviction cannot be altered to 1 under section 304 part 1 or 304 part 2 of the Indian Penal Code. Adverting to the contention raised by the Land Council for the respective parties, let us find out how far the prosecution has established that the deceased met with a homicidal death. PW, apart from the inquest report, the evidence of PW8, the medical officer of Lanjigarh Government Hospital is very relevant uh, in this regard. PW8 conducted postmortem examination on 13/6/2004, and he noticed the following external injuries. Quote kar gaye. On dissection, he found so and so, and he opined that the injuries on the head are sufficient in ordinary course of nature to cause death, and all the injuries were antemortem in nature, and the injuries on the head were fatal, and the injuries were caused by hard and heavy, sharp, edged weapon. He further opined the cause of death of the deceased was due to hemorrhage inside the brain and shock. The investigating officer sent the tangia, which was seized from the appellant, to PW 8, who examined the same and opined that the injuries found on the body of the deceased were possible by tangia, and the query report has been proved as Exhibit 3. Nothing has been elicited in the cross-examination to dislodge the version of PW8. In view of the available material on record, particularly the inquest report, the evidence of PW8, and the postmortem report Exhibit 2, we are of the view that the Lenin trial court is quite justified in holding that the deceased met with a homicidal death. Now, adverting to the evidence of the 4 eyewitnesses, that is PW 1, 2, 3, and 4 are concerned. PW1 is the informant in the case, and he has stated that on the date of occurrence at about 9 a.m., while he, along with his deceased brother, Chuman, and others had been to the tank in his village Sitapur to catch fish at about 9 a.m. A quarrel ensued between the deceased and Hathi Sahu. As Hathi Sahu took exception as to why the deceased was always asking for money which he had advanced to Shatrugna Sahu, the brother of Hathi. He further stated that at that point of time, the appellant came there riding a cycle, putting a tangia on his cycle, parked the cycle on the embankment of the tank, put off his shirt, rushed towards the deceased, carrying the tangia, and dealt blows on his back and backside of the neck and stop. PW1 has specifically stated that by remaining present on the other side of the water of the tank, which was about 100 feet, he saw the incident. And after the appellant ran away towards his house carrying tangia, he rushed towards his deceased brother and found him dead. He further stated that he got the report scribed by one S.K.Sahoo, and it was lost at Vishwanathpur outpost. The first information report also indicates that the officer in charge received the report from the outpost, and thereafter the FIR was registered. In the cross-examination, PW1 has stated that Shatrugna was not returning the money taken from the deceased, for which both of them were quarreling frequently whenever the deceased was demanding money. He further stated that there were exchange of words between the deceased and Hariram on the embankment of the tank. Nothing has been elicited in the cross-examination to dislodge the version of PW1. Thus, the version of PW1 as an eyewitness to the occurrence has remained unchallenged. PW2 has stated that while the deceased and Hariram was quarreling, the appellant came in a cycle and carrying a tangia, assaulted on the neck, for which the deceased fell down. Then the appellant gave 4 to 5 blows with the tangia and fled away, carrying the tangia with him, and the deceased died at the spot. PW2 has stated about the presence of PW1 at the spot. He has also identified the tangia as MO1, by which the deceased was assaulted by the appellant. In the cross-examination, he has stated that he saw the incident from a distance of 100 feet. Nothing has been brought out in the cross-examination of PW2 also. PW3 and PW4 have also stated about the assault made by the appellant with a tangia on the deceased, and thereafter the appellant running towards his house carrying the tangia. The evidence of these two eyewitnesses have also remained unchallenged. The version of the eyewitnesses, as rightly submitted by Mr. Pradhan, is getting ample corroboration from the evidence of the doctor bracketly PW8, who have noticed number of chop wounds on the body of the deceased. PW5 has stated about the appellant carrying a tangia entering into the outpost, which was seized as per seizure list exhibit 4. The constable of that outpost, Vishwanathpur outpost, who has been examined as PW7, has also stated about the appellant coming to the outpost with a tangia bracket MO1 and producing the same, and about the preparation of seizure list exhibit 1. This tangia, as already stated, after its seizure by the IO, was sent to the doctor bracketry PW8 for his examination and opinion regarding possibility of the injuries noticed on the body of the deceased with such weapon, and the answer was in affirmative. The IO had also sent the tangia through court for chemical examination, and the chemical examination report has been marked as exhibit 13, and it shows that human blood of group A was found on the tangia, and the same blood was also found in the wearing apparels of the deceased, that is check lungi, red towel, blue banyan, and therefore the production of the tangia by the appellant with bloodstain of human bloodstain of the deceased on it is another relevant feature in this case. Therefore, on the overall analysis of the evidence, it can be said that through the evidence of the eyewitnesses and the doctor and the witnesses like PW5 and PW7, the prosecution has successfully established that it was due to the assault of appellant by means of tangia, repeated blows dealt by the tangia, the deceased died. Coming to the contention raised by Mr. Tripathi that the case would come within the purview of grave and sudden provocation, it appears that the appellant was nowhere in the picture when there was quarrel between the deceased and S.K.Sahoo in relation to the demanding of money by the deceased. The appellant came all on a sudden and dealt repeated blows, and the blows were dealt on the sharp side of the tangia on the vital part of the body. Exception 1 to section 300 says that the culpable homicide is not murder if the offender, whilst deprived of power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation or causes the death of any other person by mistake or accident. Here the deceased has not given any provocation to the appellant at all. Therefore, this exception 1 is not at all applicable. So far as exception 4 to section 300 of the Indian Penal Code is concerned, it says that the culpable homicide is not murder if it is committed without premeditation in a sudden quarrel in the heat of passion upon a sudden without premeditation in a sudden fight in the heat of passion upon a sudden quarrel and without the offender having taken undue advantage or acted in a cruel or unusual manner. There was neither any sudden fight in this case nor sudden quarrel between the appellant and the deceased, and the manner in which the deceased has assaulted, the appellant has assaulted the deceased, if even after he fell down on the ground after receiving the first blow on the head, shows that the appellant has acted in a cruel manner. Therefore, the exceptions to section 300 are not applicable in the case on hand, and the question of culpable homicide amounting to murder doesn't apply in this case. In view of the foregoing discussions, we are of the view that through the evidence of the eyewitnesses and the evidence of the doctor and other evidence as discussed above, the prosecution has successfully established the charge under section 302 of the Indian Penal Code against the appellant. We find no infirmity in the impugned judgment. Accordingly, the jail criminal appeal is dismissed. The conviction, the impugned judgment and order of conviction of the appellant under section 302 of the IPC stands confirmed. The appellant has been directed to be released on bail by this court as per the order dated 11/8/2014 in Miss Case number 57 of 2014. The appellant shall surrender before the London Trial Court within a week from today, failing which the London Trial Court shall take immediate steps for his arrest to serve the sentence as imposed. Put a note of appreciation on Mr. Tripathi and Mr. Pradhan. Mr. Tripathi, you are engaged as amicus curiae?
No.
Okay, then we have to pay.
No.